The last order was stated that a reply has to be filed on the NI's objection, but we're in the opinion that instead of filing a reply, we'll go for a hearing. So today we are appearing for a prayer for a joint date for.
Then we hear the matter today. Except adjournment, we are doing nothing. This is not the purpose of the special division bench is sitting. We hear it today. We're not going to adjourn these matters. Have you seen the order sheet? Except adjournment, you have taken nothing. For how many occasions? Bench has to be reconstituted. That is not the purpose. Either you withdraw your challenge or you proceed. How many occasions have you taken adjournments? Yes, Mr. Gogoi, from your side also.
Yes, sir.
How many occasions?
Yes, sir. Multiple occasions.
Multiple means
Yes, sir.
the order sheet will be bulkier than the
Yes.
case records.
Yes, yes. So, Lordship, last time we both on 26 February, Lordship. Yesterday also, his senior told me that Lordship, he will be out of station. Lordship.
No, we have it for hearing, but we are not going to adjourn this matter. Tell us a firm date, no adjournment.
26 February, Lordship. This February. All three cases, Lordship. Malad bhai, kindly reflect the order also, Lordship. On 26 February, it will be taken for final consideration.
What is your name?
G. Kaushik.
Sri G. Kaushik, learned counsel for the petitioner, has submitted that though on the last date, a request was made for filing response to the objection filed by the NI, such response may not be necessary. Full stop. He has accordingly paid for adjournment. Sarah? A cursory glance at the order sheets would show that these matters have been adjourned on multiple occasions. Full stop. This bench being specially constituted for adjudication of this matter, request for adjournments. Request on further adjournments would not be. Request for further adjournment should not be made. Full stop. Be that as it may, and in the interest of justice, the matters are deferred to be listed for hearing on
26.
The hearing, full stop, as agreed to by the learned counsel for the parties. List for hearing on 26. Two.
Lordship. Lordship, I have a prayer also.
26.
Yes.
Two.
Lordship, in this case, Lordship, earlier two occasions we have Lordship submitted before Lordship that the objection filed in the appeal may be treated as a Lordship. Loss.
Those technical things are not a problem for us.
Loss.
But 26, we go ahead with the final hearing.
Loss.
All three matters.
Loss.
Much obliged.
Obligation.
Opinion is not.
Yes, what is it, Mr. Jain?
Lordship, Mr. K.N. Chaudhary will be assisting in this matter. He has some personal difficulty today, Lordship. So can it be taken in the month of February, second week?
Inform Mr. Dasgupta
Yes, Lordship.
on a prayer made on behalf of the petitioner. Matter is adjourned to be listed when?
Lordship, second week of February.
Listed on 10th of February,
Lordship.
10-2.
Much obliged.
Happens, Lordship. Lordship, I beg to mention for listing the matter, Lordship. On Wednesday, Lordship.
Motion matter.
Yes, sir. Lordship. Obliged, Lordship.
Make it. Let's prepare for listing, Lordship. On read petition number 252924.
What is the urgency?
Any date, Lordship.
What is the urgency?
Urgency, Lordship. I am the highest bidder, Lordship.
We are not on the facts. What is the urgency? Mention memos are not for that purpose. It is for motion, it is okay. For admission orders, it has to be extremely urgent. Yes,
May it please your Lordship. I beg to mention item number 13, prayer for Passover.
12,
13, sir.
13, yes. What is it?
Lordship.
What is your prayer?
pass for adjournment,
On behalf of whom?
on behalf of SH Sigdar.
Inform the forest department. Have you informed the forest
No,
department?
not
You have to inform first, then you make a mention.
Oh.
That would be counsel of the forest department. Maybe they're in the code itself. Yes, next.
Obliged.
Sharma,
What's a pray for listing of a petition, my lord, a motion matter, my lord? My lord, on Tuesday, my lord.
whenever.
Unobliged. May it please your lordship.
Yes,
Lordship, I beg to mention item number from 4 from today's list, my lord.
yes.
In this matter, my lord, respondents have filed one affidavit, my lord. We want to file in reply, my lord.
When did they file the affidavit?
My lord, in the year 2024 itself, my lord.
24, then we are in 26.
My lord, kindly
If you have
allow
not filed affidavit in 22 years, we are not going to grant you time.
one week time. Last chance may be given, my lord.
Let it reach.
Kindly, my lord,
Let it reach.
a week's time.
Let it reach.
I'm highly
We'll
obliged.
see what is the matter.
May I please have your lordship, with the consent of the other parties, I beg to mention item number 1 for adjournment.
One is 17 matter. Why are you making a prayer for adjournment of a 17 matter? What grounds?
My senior is not present due to some personal difficulties.
Who is your senior?
Dr. A. Todi.
17 matter. How do you make an adjournment request? We're in 2026, 9 years of a writ petition. When can he come? Tuesday next? Tuesday,
Okay.
Tuesday. No further adjournment. Tuesday. Have you informed the other side?
Yes, my lord.
A prayer for adjournment has been made on behalf of the petitioner. Full stop. On personal grounds. Para. This writ petition is, however, pending since the year 2017. Full stop. Para. As an exceptional circumstance, matter is adjourned to be listed for admission hearing on Tuesday, 27,
Much obliged.
27/1. Yes. Yes, please.
Let me ask for the petitioner law. Time to file a reply law. You have filed a affidavit on 5/1/2026 law. Some time may be.
20. Item number?
23.
Supply list.
Yes.
Supply list.
Yes, Lord.
Okay. You're for the petitioner. Okay. It's a award. You're challenging an award or what?
Yes, sir.
A request has been made on behalf of the petitioner for grant of time to enable filing of rejoinder affidavit. Para? In view of the above, matter is adjourned by 3 weeks to enable filing of such rejoinder affidavit. List on 3 weeks. We have said 1, 2, 3. List on 16th of February. File it within this time. Is there an interim order?
No.
Yes, madam.
May it please your lordship, we are listing for contempt case on motion.
Fresh matter.
Yes,
When did you file?
2026.
Okay, motion matter, it will come. Yes.
Yes, in the year 2024, August, my lord, I was given a settlement to run a ferry by the Inland Water Transport Department. That is valid up till 31st of March 2026. In the meantime, my lord, the Hajo Anchalik Panchayat on 16th of December 2025 floats another tender for the same ghat, and respondent number 10 has now been given the tender settlement also.
Your settlement is up to?
20 March 2026, my lord, which has been given to me on 30th of August 2024 by a valid tender process. And I have been running it, completed all the formalities. Subsequently, my lord, now the...
What is the name of the ferry?
Yes, my lord, this is for
Milpara.
Milpara, Tapobari, Kalajal and Mora. Now the ghat remains the same, but they are saying that there is a jurisdiction issue for inland water and Hajo. Therefore, they had to do some kind of a verification. In terms of which we wrote and said, please don't proceed with the NIT if you have issued, because this will have to be decided. It is their letter to us. So in the meantime, before going for a spot verification, they have already issued and given it to somebody else now. And subsequent to this, the BOD has written, BDO has written a letter to the police saying that we have not been allowed to run.
Where are the ferry rules?
Yes, my lord, I have. Well, may I just take your lordships to page 30 once, if it is
30?
30.
Yes.
This is a letter from the IWT, my lord, for immediate cancellation of the tender floated. Subject, my lord.
Yes.
Yes. The second paragraph, my lord. It has, however, come to a notice that Hajo Anchalik Gaon Panchayat has floated a tender for ferry services operation at a point falling within the jurisdiction of the aforementioned notified ferry services. The said point, namely so-and-so, falls under the operational area of the said settled ferry services, and thus action taken by the Gaon Panchayat is in direct violation of the ferry rules. The overlapping tender process not only creates administrative confusion and jurisdiction conflict. In terms of this, my lord, the next page is very important, page 31. So Hajo Development, my lord, subsequently adjourns the tender process, which is at page 31.
Yes.
Subsequently, they write a letter to us, to the Inland Water Transport as serving to us. That, my lord, the third paragraph is extremely important at page 32.
No, those you have already submitted.
Yes, ma'am.
Those we have taken note of.
Yes, ma'am.
What are the rules?
Yes, my lord, the rules are here. Now, the only dispute that can arise, my lord, is whether the Schedule A, which speaks about the 812 Ghats, whether it falls under that. Now, the jurisdiction wise, my lord, there's a valid tender process I have been given to by it. So would it be fair enough today to say that no, that's because somebody's jurisdiction is existing? Without even setting aside and informing me, my lord, now they have given it to
What
somebody.
is the distance to be maintained? 4.8.
Yes.
What rule?
Yes, my lord, it is here. Just 1 minute, I'm sorry, just 1 sec. No, what is it? I'm sorry, my lord, distance is 3.2, I'm sorry.
3.2.
Yes, my lord, 3.2. My apologies.
What rules?
This is, my lord, this is the Control and Management of Ferries Rules 1968. Which governs these tenders and the process and everything, my lord.
Okay. Mr. Malakar, for whom?
For a KPA to Lordship.
The-
Position of the safe Lordship. Lordship.
No, before you, we'll hear you, but who's for the Panchayat? You had given this settlement.
As per section 105 of settlement of Ghats by Anchalik Panchayat.
No, understood. No. You're for the Panchayat. What have you, how have you done? Mr. Malakar, you are the settlement holder. You may not have a role in the decision-making process, but you may justify that it is fairly done or legally done. But there are a statute, Northern India Ferry Act and the rules of 1968.
Lordship, earlier they have approached the police honorable court by filing the writ petition also. And on those actually petition, they have already withdrawn those petitions. And department actually discussions were going on since 2022, Lordship. And recently also they visited, but they
Now,
are
what is
not-
what is the outcome of the discussion?
Lordship, that I do not.
Then, if the discussion, you are also admitting that there was some discussion. See, your authority may have a jurisdiction to settle a ferry.
That falls under Hajo Anchalik Panchayat.
So, but it cannot overlap. And the annexures at page 30 and 31 would show that the authorities were in cognizance of this issue and it was tried to be resolved.
I am the highest bidder and
No, we are not on you're not on the allotment, we are on the process. So far as your allotment is concerned, your highest bidder, we are not finding fault with that. But whether a process could have been initiated on an existing area where the Inland Water Transport is already made the arrangement and his tenure is up to 26.
Lordship, in
Third.
their order, in the settlement order, Adabari, Sialmari, Kuriamari ferry service, there is no mention of our ferry ghats, Lordship.
Page
There is no
24.
particularly mentioned in our ferry ghat service. Earlier, that actually ferry ghat was operated by the Hajwan.
Then we can clarify that within 3.2 radius, your ferry will not be allowed to operate. Outside that you operate, there is no bar.
Absolutely. Let them clarify.
Madam, Bora?
Page 30. Kindly have a look, page 30 once again, madam.
Madam Bora, you should have resolved the issue. You are the department.
Lordship, we are trying to do this, that's why.
There should not be any conflict between two departments. Ultimately, you and the PNRD.
Lordship, may kindly dispose of the matter directing the authorities. So.
No, you cannot dispose of. Mr. Malakar has some right has accrued upon him. Whether rightly or wrongly, we do not know at the motion stage.
Page 30, Lordship, may kindly have a look again, my lord, page 30, it's a 5. This is a letter written by the executive.
No, thereafter, what had happened? This was in
There are page 32, my lord, my kindly. Page
32. Yes, please.
letter written by the chief executive officer
Mm.
to the executive engineer IWT. Reference, may I read, madam? With reference to the subject, I am enclosed here is xerox copy of the letter along with the enclosed receipt from the BDO Hajjo Development Block and executive officer Hajjo and.
Same date.
Yes, 15/10/20.
31 is also 1510.
Yes, madam. Same day, same day, same day.
In this regard, I am to inform you all that as per information received from the BDO Hajjo, which is later number above, the Hajjo Ansaric Panchayat has temporarily adjourned the tender process of the above mentioned part. Further, I am going to state that the BDO Hajjo has write this letter at reference sir. To need to attention to needs to conduct an official measurement to verify the actual jurisdiction of the said Hajj in presence of the officers from Hajjo Ansaric Panchayat, so that the ongoing dispute between IWT department and Hajjo Ansaric Panchayat can be resolved permanently. So Lordship, I will get instruction for what is the outcome of that. So the date 15/10/2025, whether any discussion was going on, what they have.
And in spite of writing this letter, my lord, that there is going to be a joint verification or something, they still go ahead and give it the settlement in the month of December. That is the difficulty, my lord.
Yes,
I could have understood if it was not done, some kind of a settlement would have arrived. But that never happened.
You are on caveat, Mr. Malakar. Where is your caveat?
Our settlement is still March 2026.
And his statement that they are in possession may not be entirely right, because page 36, your lordship should just, they have said that they want possession.
We'll balance it. We'll balance it.
That's what they
We'll
said.
balance it.
Yes.
Heard Sri M. Malakar, learned counsel for the caveator who has lost the caveat for an order dated 16/12/2025 passed by the executive officer cum ex-officer secretary, Hajjo Ansaric Panchayat with regard to settlement of the Milpara, Tapabari, Kalojol, Moranodi Ghat. Full stop. The caveator would be heard in the event this court proposes to pass any interim order. Caveat stands discharged. I main repetition. Heard Sri R.B. Fukan, learned counsel for the petitioner who is aggrieved by an order dated 16/12/2025 issued by the Hajjo Ansaric Panchayat, whereby the so-and-so ghat has been settled in favor of the respondent number 10. Full stop. It is the case of the petitioner that in a validly conducted tender process by the Inland Water Transport Department, the petitioner was settled with the aforesaid ghat, and the period of settlement is up to
31st of March.
26.
31st of March, 2026.
31st of March.
2026.
31/3/2026. Full stop. However, during the pendency of the said settlement, a move was initiated by the Hajjo Ansaric Panchayat for settlement of a ferry in the same ghat. Full stop. The learned counsel has drawn the attention of this court to communications exchanged between the IWT and the authorities in the panchayat, whereby the tender process initiated by the panchayat was also adjourned, full stop. However, without bringing the matter to a logical conclusion, the impugned settlement has been made. Para. Miss MD Bora, learned Standing Counsel, Transport Department has submitted that the settlement in favor of the petitioner was validly done, and which is up to 31/3/2026. Para. Sri G. Malakar, learned counsel for the respondent number 10 caveator, has submitted that in a validly conducted settlement process, his client has emerged as the highest bidder and has been duly settled with the ferry, and has also taken possession. Para. Let notice be issued returnable on, yes, which date? On 16th, can you file your 16th? Or 19th? Or 18th week probably. Mr. Fukan? 18th? Can you file your counter, Mr. Malakar? On 18th of February 2026. PNRD, who's there? Your name? A.K. Ghosh. Sri A.K. Ghosh, learned counsel, appearing on instruction of Sri S. Dutta, Standing Counsel, PNRD for 1, 1, 6, 8, and 9.
And for 3.5.
Miss MD Bora, Standing Counsel, Transport Department 2, 3, 4, 5. What about 6?
6.
Oh, you have taken. Then 10 is Mr. Malakar, M. Malakar, for respondent number 10. Extra copies be served. Para. Sri Fukan, the learned counsel, prays for an interim order. Full stop. The same is, however, resisted by Sri Malakar, the learned counsel, for the respondent number 10, by submitting that his client has already taken possession of the ferry service. Para. Rules.
Yes, madam. Yeah, just hand over the rules, madam.
Yeah, the point. Not the whole application.
Which rule?
Yes, madam, that, I don't have the, I have, I'm sorry, it's will be marked with a pen. I'm sorry.
No, with 3.2 kilometers.
Yes, my lord, I have marked it with a pen. I'm sorry. At the end of the rules. my lord.
Okay, no, we'll clarify that. We'll clarify that. Yes. Rule 35
35.
of the Control and Management of Ferry Rules 1968, which have been framed under the, what is the name of, under section 12 of the Northern India Ferries Act 1878, lays down that recognized non-transport ferries can run within the distance of 3.2 kilometers on either side of the ferry. This court is also prima facie satisfied with regard to the aspect of a conflict of an overlapping of the jurisdiction, which appears from the communications exchanged between the Transport Department and the Panchayat, including the communications dated 3/10/2025 and 15/10/2025. Para? Considering the above, comma, it is provided that till the returnable date, comma, while there may not be a blanket order of stay of the settlement made in favor of the respondent number 10, comma, the prescription of law as laid down in section 35 is to be strictly adhered to. In other words, comma, the area of operation of the respondent number 10 should not clash, should not come within the prescribed distance of 3.2 kilometers on either side of the Ferry settled with the petitioner.
Extremely grateful.
Milpara, Tarabari, Kajol, Sarprasalo. Yes. At your number?
My lord, matter relating to supply of
I think.
vehicle
Okay.
at the APDCL department. And in the year 2023, a tender was invited for supply of some vehicles, and petitioner number 1 became the L1. Thereafter, he did everything, my lord. In the year 2025, again, another tender has been,
The first tender was cancelled.
no, my lord. I have
You're running.
completed, yes. I am
Okay.
still supplying,
Okay.
and
So what is your
thereafter,
grievance?
my lord.
What is your grievance?
Yes. My lord, in the year 2025, new tender has been invited, where some points are, my lord, there are many anomalies and discrepancies. Let me show the differences first. My lord, first of all, if we go to the page 18 of the earlier tender, some vehicles, list of vehicles are there. In the year 2025 also, almost same vehicles are there. But the problem is this, my lord, earlier the tender value was at rupees 4 crore. And in the year 2025, it is increased up to 18 crore without any reason, my lord. Tender value with same vehicles, my lord, first of all.
Same vehicle, numbers are same.
Yes. List is as page 18 and page 45, my lord. Different.
Same numbers of vehicle.
Yes,
Description is the same.
same. My lord, page 18 is the 23 and
It is for procurement or supply.
supply of vehicles for daily basis or monthly basis.
Oh, hiring charge.
Yes,
Hiring.
yes. Monthly and daily. Where if we look into the monthly, same, my lord. And daily is also same.
So how does it make a difference? What is the?
Yes, but the problem is this, my lord, as because the value has increased, the annual turnover is also increased. The EMD, security deposit is also increased, and exemption is not given specifically. And if we see that 23 tender, exemption to the MSC is there, micro and small are there. At page number, my lord, 16 is the earlier tender, but in the year 2025 new tender, that exemption is curtailed, which is at page 40. So being a micro or small, I am not be able to participate in the new tender without those exemption. And the reason is shown as there, my lord, the earlier.
You are a micro.
Yes. And registered under Wisdom.
Under?
Wisdom certificate is there.
Okay.
And my lord, the most important thing is this, that as per the policy of procurement rule 2021, as per the that policy also, micro is considered as annual turnover up to 5 crore. But in the new tender, it is fixed at 6 crore, man.
Well, what is the stage now?
As per the
Present position?
as per the new tender, on my lord 28th of January, the technical bid was to be supposed to be open, but as per my instruction, that was not opened on 8th of January, my lord. So
Zero
it is
eight.
at the stage of technical bid. My friend would enlighten that much, my lord. But the subsequent pre-bid meeting or financial bid, that is not open yet. So as because the value is increased and the EMD as well as turnover is increased, which is a clear violation to the policy of 2021, madam. Because
Yes, Mr. Pathak?
Firstly, technical bids have been opened, they are being presented. I have given instructions to them.
It has been opened. When?
it happened, after you-
When?
On the same,
8th.
on, yes, on as per schedule.
But today I have my instruction that it was not open.
When are you opening the commercial bid?
Technical bids are being evaluated. As soon as the evaluation process, I expect it to take at least.
How do you answer, how do you respond to the main
Regarding
challenge?
the query regarding the application of the MSME Act and the.
That was, I think,
Yes,
one,
that your lordship had already.
one case we had already.
Had gone up to the division bench also declined to interfere. Regarding this change in valuation, the lordship has the matter tomorrow, I can have written instructions to that effect. I this.
Tomorrow is a holiday.
On Monday.
Monday is
Because
also a
technical
holiday.
bids-
Till then, my lord,
On,
status quo being maintained.
No, there we cannot stop assessment of the technical. We can say that do not open the commercial bid.
Yes, yes. Because
That is making an undertaking by tomorrow, Tuesday, it's not being going to be
yes,
open.
Tuesday it will not be open. Tuesday I'll produce it.
Tuesday, we can have the
Madam.
instruction.
Lordship
Okay.
may have it for motion, I'll produce it.
Yes, yes.
because due to the problem, I could not actually participate. So
And-
that is to be looked into. Because it curtails the micro enterprises conditions, my lord, as per the policy of 2020, which is a
Heard.
clear violation.
they cannot,
They cannot.
Learned Counsel for the petitioners who is aggrieved by a tender process initiated by the APDCL for procurement of vehicles, full stop, amongst others. It has been contended that the value of the tender has been unreasonably increased, which led to corresponding increase in the in the requirement of EMD, annual turnover, security deposit, etc. Right, full stop. He has also highlighted that there is no exemption to the micro and small units. Full stop. Para? No, para no. This Learned Counsel has also submitted that though the technical evaluation was scheduled on 8/1/2026, the same has been deferred. Para? Per contra, Sri KP Pathak, the Learned Standing Council APDCL has submitted that the technical evaluation was indeed opened on 8/1/2026 and the assessment is undergoing. Full stop. He, however, undertakes to obtain necessary instructions on the merits of the challenge, for which he prays for some time. Para? He has also submitted that till the next date, the commercial bids would not be opened. Para? In view of the above, and also taking into consideration the urgency of the procurement process, let this matter be listed for motion on Tuesday, by which date the Learned Standing Council APDCL shall obtain the instructions. Okay. To facilitate Sri Pathak, the Learned Standing Council, to have the instructions, let an extra copy be served upon him during the course of the day. Yes, Mr. Sharma.
So in this case, my record is misplaced, so I need some time to procure a record.
It did matter.
18 Lord, 2 weeks time.
Is there anything? Nothing, there's nothing in this matter.
I have to actually,
There's nothing.
Lord, I want to verify.
You have have a look at the court records. Is the client in touch with you?
Yes, Lord.
They are.
Yes.
You can check the court records. You can take the second file.
Also, I have to read it, though. I need time, some time.
Time, your requirement is not very sacrosanct. 2018 matter. We are giving you time, take the second file, we'll have it after some time, after an hour. Okay, if you have grave difficulty, we'll reconsider, but I don't think there is anything in this matter. Second file to deduct. Item 3. None appears for the petitioner on call, whereas the state is represented by Ms. Udas, the London State Council, para. On the last occasion, that is 7, this matter was listed last on 7/6/2023, when the earlier set of counsel had submitted that the brief was taken back in the year 2022 itself. Full stop. This court had accordingly granted time to the petitioner to make representation. Full stop. However, after passing of more than 2.5 years, no steps have been taken by the petitioner to make representation or to engage fresh set of counsel or to make representation. Para, it appears that the petitioner has lost interest in this interest in prosecution of this case. Para, the petition accordingly stands dismissed for non-prosecution.
Please, your lordship.
Yes.
My lord, the respondent has filed affidavit long ago, my lord, but
Yes.
we have not filed any reply to
This
that.
affidavit was filed on 16/12/2022.
Yes, my lord, yes, my lord, 16/12/22.
23, 24, 25. 3 years.
Yes, my lord. My
So you
lord,
are not going to grant you
because,
time to file rejoinder.
we have, our license has been cancelled, my lord. It will not any, my lord, for one chance if lordship gives, my lord, it will not make any harm to them, my lord. Because we are praying to restoration of our license, my lord. That
One
is the
chance
thing.
to whom?
My lord,
One chance for whom? Let's decide the case. There's nothing to be decided.
here is that my lord, an inquiry was made, 3 inquiry was made, my lord.
Yes, let us see your facts.
Yes, the inquiry report has been prepared, that is your lordship will find, and
Give us the facts.
yeah, I am the, my lord, fair price shop owner, my. So PDS article, I have done some anomalies, it has been alleged that some anomalies I have done. My lord. So my lord, an inquiry has been made by the sub-inspector of Food and Civil Supply. So my lord, he has alleged that I have not distributed the PDS articles as per norms. There is the inquiry report here submitted. So I have been issued with the SOCOS notice by the Deputy Director of Food and Civil Supply.
Date,
But no inquiry report has been furnished to me.
date.
Yeah. SOCOS has been, my lord, date 19 June 2018. Inquiry report is 11 June 2018. Inquiry report,
Yes.
so my lord,
96, the SOCOS has been, notice has been served upon you.
yes, notice has been served after inquiry. After inquiry, order has been passed. Subsequently, SOCOS has been issued. Why I have been done so and so, so and so, so and so. He has, first he has suspended the license.
When
Then
was the
SOCOS has
suspension?
been issued.
Yes, suspension is one, when?
Suspension is 11 June 2018.
Yes,
Then SOCOS has been issued
yes,
on 19 June 2018.
yes.
So, my lord, subsequently, my lord, again on 19 June, another so additional SOCOS notice has been issued by Deputy Director.
Additional.
Yeah, on 3/8/2018.
No, no, you said 1906 itself. Same date you had said.
Yes, SOCOS, one SOCOS is issued by Deputy Director was on 19/6/2018.
Yes.
Subsequently, based on the same inquiry report, subsequent additional SOCOS notice has been issued on 19/6/2018 again.
Same date.
So no, sorry, 5/8/2018. So
Five-
3/8/2018.
3/8.
On the basis of said inquiry, SOCOS notice,
Yes.
alleging that I have done some anomalies, so and so and so.
Did you file your response?
Yeah. The response was on 3rd occasion, I have filed my response.
When? 3rd
That,
August.
yes, again, my lord,
When did you file your response?
my response I have filed on 8/11/2018.
8/11/18, file response.
Yeah, that is when my lord, additional deputy commissioner issued
Okay.
SOCOS again.
Then what happened?
So additional deputy commissioner issued SOCOS on 5/18/2018.
Hmm.
Additional deputy commissioner. So he's the appellate authority. Additional deputy commissioner is an appeal lies before him. So to the additional deputy commissioner or deputy commissioner, my lord, food and civil supply. Then response I have filed. Then subsequently my license has been cancelled as per impugn order dated 2/9/2022,
The page?
page 23 by the deputy director.
Yes. What are your grounds of challenge?
He has denied, my lord, such
No, the
allegation.
grounds of challenge.
Yes, but because my lord,
We cannot go into the merits. What is the fault in the decision-making process?
of fault, my lord, additional deputy commissioner is the appellate authority, my lord. Deputy director is the licensing authority. Appeal lies before the deputy commissioner, who is normally done by the additional deputy commissioner. So under this PDS article order 29, appeal lies within 30 days. But here the additional deputy commissioner himself has issued SOCOS again. That's why, my lord, that these things I may be allowed to bring, my lord, my
No.
additional, sorry, reply to the affidavit.
Not required.
If your lordship gives 1 week time, my
No, but the order is passed by the impugned order is passed by the deputy commissioner. So,
stay, because deputy commissioner was the same appellate authority and entertaining the, my lord, that is SOCOS notice and reply.
see, the primary authority here is the deputy commissioner who has cancelled the license. Deputy commissioner would not be the appellate
No, no.
authority.
Yes, additional deputy, my lord, license has been cancelled by,
Deputy commissioner.
no, deputy director. Some other technical irregularities, deputy director has cancelled the license. You have a page 24. Bottom, my lord. Deputy director.
Where are the 1982 rules?
Yes, but
As
there's-
a order
there's a-
supply-
I have not brought also, my lord, the rule.
Some supply orders কোন আছে না?
29 minor that appeal lies.
1982 আমার টাইপ করা আছে। Supply orders. Yeah, appeal lies before whom?
Deputy commissioner.
Why didn't you file an appeal?
Yeah. No, here the irregularities is there. Additional that the appellate authority has also issued SOCOS.
Let us see that. Page
Yes, page 16.
16.
Yes. To so and so, additional SOCOS, earlier SOCOS notice that he has covered every, the earlier SOCOS notice are issued by deputy director. Yes, appeal lies before him. He is for food and civil supplies. This additional deputy.
Just a minute. We'll come to you. We'll come to you. Don't be in a hurry. We'll come to you. Have a seat, Mr. Borua. We'll come to you. But this show cause notice is was not by the deputy commissioner. It was by the additional deputy commissioner.
My lord, additional deputy commissioner, the official that decorum, my lord. Or the additional deputy commissioner did not do anything in respect
No,
of
how
food and
does
civil
how
supply.
does it vitiate the proceeding?
No,
Appellate
he-
authority is the deputy commissioner. How do you equate an additional deputy commissioner
No, here
to the
the,
deputy commissioner?
here the additional deputy commissioner has also covered up the notice issued by the deputy
So what
director.
prejudice?
Yes, no. Then how, my lord, this deputy director passed that impugn order?
So what is the prejudice?
No, prejudice is
If you
there.
can show, if you can show that the impugned order has been passed on extraneous circumstances, on irrelevant factors, you make out a case. You have been given an opportunity. It is not your case that there has been violation
No,
of the principle.
opportunity has been
Then
given.
What is the fault?
What is
No,
technically correct, my?
the projection which your side tried to make, that the appellate authority has also interfered in the decision-making process,
Yes,
that
yes,
is not
my lord.
correct.
Yes, my
That
lord.
is not correct. That is by
No,
the ADC.
additional deputy commissioner is in charge of the deputy commissioner, my lord, of food and civil supply.
What kind of submission is this?
The additional deputy commissioner, I see, your lordship will
I
buy
see of food and civil supplies. He
the
is not
food
the
and civil
appellate authority.
supply.
He is not the appellate authority.
Well, normally deputy commissioner is the appellate authority. So in respect of
What
food.
normally? He is the appellate authority. There is no normally or abnormally. There is only one appellate authority. And ADC is much ranked below the DC. If you have any other point, you please urge, we'll consider.
No, any other point means that whether deputy director sum up the proceeding of additional deputy commissioner. He's the higher authority.
Nice. Lordship, earlier.
Oh, Mr. Barua, please sit, have your seat. Please, don't be excited. We have not decided. We'll hear you. See, Mr. Sinha, you have brought to the notice of the court. There are two notices, show call. One is of 11/6, whereby your license was also suspended, and the other one is 19/6.
Show cause.
Show calls.
Yes.
That is by the deputy director. Now, you say 8/3/8/18, there is an additional show cause, 3/8/18
Yes.
at page 16, isn't it?
Yes, 5/10/2018 by additional deputy commissioner.
5/10, 5/10.
5/10/2018 is show cause issued by the on the basis of same report.
Let us see whether there is a show cause. ADC. So, wait, let us see page 16. What are the contents?
Yeah, it has been
Whereas it has been
revealed from the inquiry officer submitted on 24/8/18 and regarding so and so 8/8/18.
This is only giving certain details. This is not not additional grounds.
That's why
It is only
reply.
giving-
That's why the reply I prayed for reply to file.
That is rejected. After 2.5 years, we are not going to give time. Paisa nahi bolo, 82. Nala 55 page na. Full order. Sorry, pass page order. 1982. So supplies order. Supplies. So,
29, man.
If the order is not the pillar to state government, if the order is made law, see here, the order can be passed by the director, then appeal will lie before the state government. Order can be passed by the deputy commissioner, a lower officer, then it lies before DC. If it is passed by the DC, it lies before the commissioner.
Yes, madam.
There is no hard and fast. That you are not prejudiced. You will not say it can be said to be prejudiced. Your appellate right to file an appeal is not hampered.
We may be allowed to file appeal then, madam. That way, madam, I may be given.
Filing after how many years? What is the prescribed period?
Prescribed period is, there is madam, no prescribed period is mentioned in.
You don't have the statute with you and you are making a wrong submission on facts.
No.
Please do not do that. We don't appreciate.
In regard to the appeal, my lord, that there is no provision there that if appeal is to be
Where
filed.
is the rules? You do not carry a copy of the rules and you are making a wrong submission. We don't expect this from Mr. Sinha. 30 days is the prescription.
Actually, I
30 days is the prescription. These are statutes. They are not on facts even.
that's why I short time, my lord, only. Because
Taking time and you make it, don't make a wrong submission that there is no, you may say that I do not know about it. You are saying that there is no prescribed period of limitation. 30 days is prescription. So how do we allow you to file an appeal? It's time barred.
time bar, my lord, appeal that within a period, so and so period, appeal is to be filed. There is no rule, my lord. Particularly in this PDS article rule. No time, my lord, time period is there. 30 days, I did not bring the rule, my lord. That's it.
Mr. Sinha, we don't want to repeat this. You are a seasoned person. Why do you embarrass the court like this? Let it is. Let us read it for you. No such appeal shall be entertained if not preferred within 30 days.
Within 30 days.
So you are saying there is no prescription. Again, you are repeating in spite of our.
That's it. That's it.
Okay. Yes, Mr.
Right.
Are you required to say anything?
I prepared another petition for setting aside the suspension order.
Okay.
Person that was disposed of, page 21. Let's start from page 21.
So suspension was challenged.
Yes, yes.
Where?
In the
WPC?
WPC for 1431 of 2019.
Order?
Order, the other one, page start from 21.
2-1.
21. Active party is at page 22. So, the licensing authorities to conclude the procedure.
What is the date of this order?
15/3/2019.
15/3/19 at page 21. Yes. That proceeding ultimately was
Yes,
concluded
yes.
and impugned order 2/9/22.
And surprisingly, not in paragraph number 8 of her affidavit, we have stated this certified copy of this order was submitted to the authority on 10 in 2022. Paragraph 8, we have stated that. So thereafter, that cancellation order was passed on.
That's all? Okay. Heard. 3B Sinha, Learned Counsel for the petitioner. Also heard 3 SR Barua, Learned State Counsel for the respondents. Para. The challenge in this petition instituted under Article 226 of the Constitution of India is with regard to an order dated 2/9/2022 issued by the Deputy Director in charge, Food, Civil Supplies and Consumer Affairs, whereby the PDS license of the petitioner has been cancelled. Post of para. As per the facts projected, the petitioner was issued a fair price shop license and was running the same in accordance with law. Full stop. However, certain allegations were leveled against him and an inquiry was done on those allegations, leading to an order of suspension dated 11/6, suspension of license dated 11/6/2018. Full stop. The same was followed by a show cause notice dated 19/6/2018. Full stop. Subsequently, on 5/8/2018, an additional show cause notice was issued by the Additional Deputy Director in charge. Full stop. The petitioner had responded to the same on 8/11/2018 and thereafter and after completion of the proceeding, comma, the impugned order dated 2/9/2022 has been passed, which is the subject matter of challenge. Where, Ms. Sri Sinha,
Yes, ma'am.
the learned counsel for the petitioner has submitted that the petitioner was not given any opportunity at this stage of the inquiry. Full stop. He has further submitted that from the materials on record, it appears that the ADC in charge had a role in the proceeding, which is in conflict with the law and unfair, in as much as the deputy commissioner is the appellate authority under Rule 30 of under Order 30 of the so-and-so Order 1982. Full stop. He has also submitted that the allegations are not correct and the petitioner was deprived of a fair opportunity to defend himself. Para. For contra, Sri Barua, the learned state counsel, has submitted that all procedural safeguards were afforded to the petitioner to defend himself in the proceeding. Full stop. By refuting the submission regarding any prejudice caused to the petitioner, the learned state counsel has submitted that under Order 29, it is the deputy commissioner who would be the appellate authority if the order is made by any officer lower in rank and the present order being passed by the deputy director, comma, there would be no prejudice caused to the petitioner for preferring an appeal. Full stop. He has also highlighted that the additional so-called notice was not issued by the deputy commissioner, but by the additional deputy commissioner, only to clarify certain factual aspects, and full opportunity was granted to the petitioner to file his response to the factual allegations. Full stop. The State Council has also drawn the attention of this court to an earlier writ petition, WPC 1431 of 2019, instituted by the petitioner, challenging the suspension order dated 11/6/2018, in which this court had passed an order dated 15/3/2019, directing conclusion of the proceeding. Full stop. The State Council has highlighted the aspect that certified copy of the said order was supplied to the authorities only on 10/8/2022, whereafter the impugned action could be taken. Full stop. The learned State Council accordingly submits that the writ petition is liable to be dismissed. Para. The rival contentions advanced have been duly considered and the materials placed before this court have been carefully perused. Para. The show cause notice issued on 19/6/2018 was preceded by an order of suspension, which was the subject matter of challenge in WPC 1431 of 2019. Full stop. This court, while disposing of the said writ petition, had directed for conclusion of the proceeding within a specified period or within 3 weeks from the date of receipt of the certified copy of this order. Full stop. The certified copy, however, appears to have been served on the authorities only on 10/8/2022, whereafter the impugned order has been passed. This court has also noticed that the suspension order as such was not interfered with by this court in the order dated 15/3/2019. Para. the aspect that the petitioner was prejudiced for preferring an appeal as provided under Order 29 has also been examined. Full stop. Order 29 lays down a provision for preferring appeal against any orders that may be passed. Full stop. Under Order 29 within bracket 1 within bracket B, it is provided that if the order is made by any officer lower in rank than the deputy commissioner, comma, the appeal would lie before the deputy commissioner. Full stop. This court is unable to accept the submission advanced on behalf of the petitioner that the additional show cause notice issued by the additional deputy commissioner in charge would in any way come in the way of preferring an appeal or its fair consideration by the deputy commissioner, as it is not in dispute that the additional deputy commissioner cannot be equated in rank with the deputy commissioner. Full stop. Para. This court has also noticed that due opportunity was granted to the petitioner, and he had in fact filed his response on 8/11/2018, which was duly considered by the disciplinary authority as reflected in the impugned order dated 2/9/2022. Full stop. A perusal of the impugned order would show that the defense of the petitioner was duly considered and all the relevant factors have been taken into consideration. Full stop. Para. The jurisdiction to be exercised by this court, the certiorari jurisdiction to be exercised by this court under Article 226 of the Constitution of India is confined to the decision-making process and not to the merits of the decision. Full stop. In other words, comma, the examination is on the aspect as to whether the relevant factors have been taken into consideration or as to whether the impugned decision is based on extraneous factors and irrelevant consideration. Full stop. The aspect of jurisdiction of the authority passing the order may also be examined, which is not the case in hand. Full stop. There is also no allegation of malafide against the malafide in passing of the impugned order. Full stop. In view of the aforesaid facts and circumstances, comma, this court is of the considered opinion that no case for interference is made out. Full stop. Accordingly, the petition is dismissed. Case law at the beginning. Also. Yes, next. Yes, Mr. Decker.
May it please your lordship. My lord, the matter relates to, my lord, the deduction of forest royalty, my lord, from my contractual bill. On earlier occasion, my lord, I approached this honorable court, praying for the direction not to deduct the forest royalty from my bills on the ground that there is no such tender condition incorporated in the contract agreement.
But those have been settled.
Yes, my lord, there's already been settled, my lord.
Now, is there anything to be decided?
My lord, pursuant to that order, my lord, impugned order has been issued that lordship will find at page 27 of my writ petition.
Yes.
May I read, my lord? Page 27.
Yes, please.
With reference to the subject cited above and in continuation to this office letter under reference number 2, I am to inform you that a sum of rupees 40,59,342 only has been realized against forest royalty from the works construction of so and so against work order dated 2/2/2019 as per prevailing government norms, and same is kept deposited in proper head of account for further necessary action. After judgment passed by the Honorable Guwahati High Court on 30/6/2022 in respect of case number under reference number 1, you are once again requested to furnish the relevant authentic document as a proof of payment of forest royalty utilized against the said work to the undersigned as soon as possible as per the direction of this honorable court, so that further needful action can be taken at the earliest. This order is under challenge, my lord. My lord, may I hand over the copy of the order dated 36/2022, my lord, for lordship's perusal.
That Alcidas, which one?
Arsian construction, my lord, the reference is there, my lord.
Name?
A batch of writ petition is there, my lord. My case was.
Dr. Saraf.
No, my lord, recent order.
Recent order-
Reiterating the same, my lord, law laid down in the division bench.
Yes, my lord, but there is no tender condition, my lord. Kindly produce, my lord.
There is a circular.
I think these are.
If there is tender condition, then we have to produce the FRCC, my lord.
No, if it's a statutory requirement,
Yes, my lord.
tender cannot be, you cannot be divorce the statute holding the field.
Yes, my lord. My lord, kindly.
Yes, RCN, we are following RCN only, I think.
Yes,
What
my lord.
is the difference?
Main leading case was.
In Muslim Ali, there is a condition, my lord. But in the instant case, there is no clause, my lord. I'll satisfy, lord.
Then
Page 69 of that judgment, my lord. Paragraph 18 conclusion. Page 69
Not 69, of the judgment.
of the judgment, my lord.
Not 69. It is, okay.
Paragraph 18 is the conclusion, my lord.
Yes.
After discussing, my lord, all the case laws and the statutes, the honorable court was arrived at those conclusions.
Yes.
And in my case, my lord, paragraph Roman 3, my lord, next page.
Roman 3.
In absence of any contract condition, when a contractor is unable to produce a certificate showing the use of forest produce on which royalty has been collected, the recovery from the bill against forest royalty cannot be made. There has to be a contract condition, my lord, in the tender agreement for deduction of the forest royalty. As per conclusion number 3, so there has to be a tender condition. Then, my lord, the next page.
Yes.
After recording the conclusion, this honorable court was pleased to issue the following direction at next page, paragraph 19.
Yes.
For the foregoing reasons, conclusions and findings, this court directs the following. The employer shall verify the contract of the petitioner herein, and if it is found that the forest royalty is recoverable in terms of the determinations, conclusions made in the present list, a reasonable opportunity to produce the proof of payment of forest royalty be granted to them. And if the contractor satisfied the authority that forest royalty has already been paid, no recovery shall be made, and a pending bill, security deposit, earnest money, etc. shall be released within 6 weeks from the submission of such materials if the same is not recoverable from any other contractual liabilities. If such proof is not available, the authority shall be at liberty to recover the forest royalty. Now, number 2, my lord. In other cases, where there is no condition of forest royalty payment, my lord, in other cases, the employer shall forthwith release the pending bill, security deposits, earnest money, etc., if those are withheld against any forest royalty. And in those cases where the recovery has already been made against the forest royalty, the same be released forthwith. In where the tender condition is there, direction number 1 will apply, and where the tender conditions are not there, direction number 2 will apply. The respondents have filed their affidavit in a matter, my lord, and they relied upon the clause number 38 of the tender condition that lordship will find in the additional affidavit. First, they relied upon a preamble, clause number 10, at page 31 of the additional affidavit. No.
The affidavit starts at page 29.
Yes.
29.
29, my lord, the affidavit.
Filed by whom?
Filed by the, my lord, the chief
Abdul
engineer, I
Motin
think.
Chaudhary.
Chief engineer, well, yeah.
Abdul Motin Chaudhary.
Abdul Motin Chaudhary.
Chief engineer.
First one. At page 31, they have quoted the preamble portion, the clause 10. AGST forest royalty, including other charges levied by the Forest Department on forest products, including any other taxes as applicable, is to be paid by the contractor. The
Which page?
Page 31. my lord.
31.
That affidavit filed on 16/7/2024.
Yes, yes. Para?
Paragraph number 5, page 31. They have
5.
quoted the preamble, my lord.
Yes.
Clause 10. AGST forest royalty, including other charges levied by the Forest Department on forest products, including any other taxes as applicable, is to be paid by the contractor. The department shall deduct the amount of AGST, FR, and ST and any taxes from the contractor's bill if the contractor fails to produce the valid certificates from the concerned department. My lord, this clause was considered. I prepared a compilation of judgments, my earlier judgments, all over there. Earlier considered by this honorable court, my lord. And lordship will find that, my lord, at page 33 of that compilation, my lord. Page 33 of that compilation, my lord. It is a part of a judgment delivered in a batch of writ petition, the lead case being 1234 of 2017.
Yes.
Page 33, paragraph number 11, my lord, the middle of the page. May I read, my lord?
Yes.
Mr. So-and-so, on the other hand, refers to clause 10 of the preamble of the concerned agreement that have been entered by the respondent PWD with the respective contractor. This clause 10 that I have just read, my lord. Paragraph 12, on a reading of clause 10, it is seen that the said clause can be found only in the preamble of the agreement and not in the terms and conditions of the agreement, which are binding on the respective parties. The preamble of the agreement is merely an indication of the subject matter on the agreement and not a binding clause of the parties. In any view of the matter, clause 10 of the preamble provides that the department shall deduct the amount, including that of forest royalty and any taxes from the contractor's bill, if the contractor fails to produce the valid certificate from the concerned department. Prima facie, the said provision appears to be directly in conflict that the office memorandum dated 17/6/2000. The office memorandum of the finance department merely requires the contractors to produce the documents in support of such forest products, minor minerals, to enable the PWD to get it verified from the authorities of the forest department. The office memorandum does not speak of any valid certificate from any concerned department. The law relating to conflict of two provision is that whenever there is a conflict between the provision in an agreement and more so in the form of a clause in the preamble and that of an office memorandum issued by the appropriate authority in the government, the provision of office memorandum would prevail over such clause in the preamble of the agreement. Now, paragraph 13. In view of such position of law, the clause 10 of the preamble has to be read that the contractors would require to produce the relevant document in support of the purchase of the forest product or the minor mineral. In such view of the matter, the reference of Mr. So-and-so to clause 10 of the preamble on the agreement also does not satisfy the requirement as provided by this court in case of Muslim Ali Supra and other, and an order passed in WPC number 1066 of 2015 that unless there is a condition incorporated in the agreement requiring contractor to produce any such document, the respondent PWD would be disentitled to deduct the component of the royalty from the bills of the contractor. So, my lord, this clause has already been considered by this honorable court, and it was held that on the basis of this clause, they cannot deduct the forest royalty from the bills of the contractor, my lord. For deduction, there has to be a specific condition in the tender condition, and it has been directed by this honorable court in the judgment. And my lord, they also relied upon clause 38 of the tender of the contract agreement. That is the perimeter of preamble clause 10 that lordship will find at page 134 in the additional affidavit filed by the department. My lord. This is the same, my lord. Page 134. Down below.
One, three, four. last page.
Page number, my lord, 134. Second last page, the
Yes.
clause is 38 down below. This is the same, my lord, only, my lord, here. I'll read AGST forest royalty, including other charges levied by the forest department on forest products, including any other taxes as applicable, is to be paid by the contractor. The department shall deduct the amount of AGST, FRST, labor cess 1%, and any taxes from the contractor's bill if the contractor fails to produce the valid certificate from the concerned department. So it is, my lord, in my humble submission, similar to that of the clause 10 of the preamble.
But this is not preamble.
Yes. But my lord,
This is a specific clause
yes,
in the
ma'am, there is
contract.
specific rule, but this rule does not permit the authorities to deduct
But
the
the,
forest
but
royalty.
the observation made by the learned
This is in
judge,
aspect of preamble, my lord.
but there is no clause. This appears to be per incurium.
My lord, yes, but my lord, there is no specific clause.
No, no,
that-
what more do you need? There is a clause. The learned judge has said, preamble of the agreement is merely an indication of the subject matter of the agreement and not a binding clause in the parties.
Yes, my lord.
But there is a clause
In
signed by the
present,
parties.
it has been now modified, my lord. It has been brought in, my lord. Earlier it was there in the preamble.
But
That
this is,
portion
my
has
lord,
been
in the,
This is signed by the parties.
this is a term, part of additional terms and condition, my lord. But my lord, since it has been considered, so my
Now,
lord,
this consideration was
yes.
without the court being taken into notice about this clause, 38. 38 will be, this observation to be par incurium.
next paragraph.
Again, can we again,
Yes,
read 33?
Hmm.
This was not brought to the notice of the honorable court, the last, on when it was, when this judgment was decided, this judgment was pronounced.
That point of time, standard bid document. This clause was not there in the contract terms.
But then
Now it has
the,
been incorporated.
now the
in the
immediate question will be there. This incorporation was done before taking into effect of this thing. Will it come, will it have operation? This incorporation was done subsequently or during the tenure, during this contract?
For this particular contract, Lord,
okay.
you will see, my lord, the signature of the petition.
Yeah, no, that was,
Yes,
no, this is a part of this contract.
yes, ma'am. Exactly this contract.
This
Yes,
contract,
signed.
madam.
No dispute about that.
Then, Mr. Deka,
Yes,
you still have an avenue. You can produce your proof for payment of forest royalty,
Yes.
which you have been passing in other cases. Give proof of,
In
give the
fact, the
documents.
impugn order says so, my lord. That opportunity has been provided to him. Yes, instead of providing the, my lord, documents, he has challenged it, my lord. The impugn order, Lord,
You can still avail it. See, a substantial amount we can realize, we can,
Yes, ma'am.
this 40 lakhs something has been.
Yes, yes, ma'am.
Now, if you can give proof of the payment, that is what this court has been consistently passing. In
Yes.
those cases also, those,
Yes, yes, the
the
recent one. Lord,
recent,
yes.
what was the name? The
Yeah.
NC Das or something?
Yes,
Then
you see construction.
the other one also.
Other one is Muslim only, my lord, main big one.
No, no, there were other cases where justice, where division bench.
Yes, yes.
Honorable Justice Chief Justice Ajit Singh.
Nine associates, my lord. Nine.
That is the 1, 2, 3 order. Has been passed by my lord Justice Pillarboram. 1, 2, 3 order, 39 associates.
Durga Krishna schools.
Durga,
Yes.
Durga Krishna, Durga Krishna.
Well, in fact, the impugn order says so that you are once again requested to furnish the relevant authenticated document as a proof of payment of forest royalty utilized against the said work with the undersigned as soon as possible as per the direction of the so and so. So, my lord, as per the honorable court direction, now we have reviewed again. We have given him the opportunity as per para 18.
My lord, for that, my lord, they have to first give me an opportunity or give me notice to go and collect the
That
materials from this particular query.
what prevents you from collecting and giving the proof?
My lord,
We'll clarify it, give the proof. And there is no requirement of clarity. This is a settled law in all cases. For we cannot be settled doubly. If you say that the forest clearance, the royalty has been paid while you had procured the goods for execution of the work, you cannot be settled again from the bills of deducting the forest royalty. It will be deducted only when you have not produced, or when you have not
no
paid.
condition.
Now you can, if you say that you have paid, how much full proof would that process would be? We have still doubts, though we have been passing orders to procure a bill.
Contempt case are still pending, my lord.
But still then. Okay, we will close this then. Where is the impugned order? Page 27.
27 on my writ petition. my lord.
An order dated, no, don't say order, a communication dated 31/8/2022 issued by the Executive Engineer, PWD, North Kamrup Territorial Roads Division, page 27. Whereby the petitioner has been requested to furnish relevant documents as proof of payment of forest royalty utilized for the work in question, for taking necessary action for release of the forest royalty is the subject matter of challenge in the present writ petition. Para. Please have your seat, Mr. Decker. The facts as projected in brief is that a work was allotted to the petitioner and for the execution of the same, forest royalty of rupees 40,593,42 has been realized. Full stop. By the impugned communication, the petitioner has been directed to furnish proof of payment of such royalty for release of the amount. Full stop. Instead of taking the opportunity to file to submit proof of such payment, the petitioner has questioned the validity and legality of the said move of the department. Para? I have heard Sri Deka, R.M. Deka, learned counsel for the petitioner. I have also heard Sri B. Gogoi. You appear as the AG.
Well, at PWD. All are
Standing counsel, Public Works Department. Full stop. The primary contention of Sri Deka, the learned counsel for the petitioner, is that the tender there was no stipulation in the tender for making such deduction, and this aspect was considered by this court in a batch of writ petitions which was disposed of wide and order dated Is it 33?
Yes, ma'am,
33, 2017. The lead case being
1, 2, 3, 4 of 17, my lord.
1, 2, 3, 4 of 2017. Full stop. In the said batch of cases, comma, this court had observed that though there was a reference in the preamble regarding reduction of various charges, including forest royalty, in absence of a specific clause in the contract, comma, such deduction could not have been made. Full stop. The learned counsel for the petitioner has also drawn the attention of this court to an order to a judgment dated 30/6/2022 passed in WPC 9227 of 2019, wherein it was wherein it was held that in absence of any contract condition, when a contractor is unable to produce a certificate showing the use of forest produce on which the royalty has been collected, the recovery from the bill against forest royalty cannot be made. Full stop. A modality of claiming such amount which has been withheld by the department has also been laid down in the form of a direction. Full stop. The learned counsel submits that the aforesaid directions would squarely cover the case of the petitioner, and accordingly, a case for interference is made out. So, para. Per contra, comma, 3. Gogoi, the learned counsel, standing counsel has submitted that the factual projection made on behalf of the petitioner is not wholly correct. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 16/7/2024 by the respondent number 2, comma, the learned standing counsel has submitted that apart from preamble 10, which stipulates deduction of charges including forest royalty, comma, there is a specific clause being clause number 38 in the contract whereby such charges are deductible. Full stop. He submits that in view of such factual position, which is not disputed, comma, the observations made by this court in the order dated so and so would not be binding, and at best it can be restricted to the facts and circumstances of that case. Full stop. Para. The rival submissions have been duly considered, and Sri Gogoi, the learned standing counsel, has however fairly submitted that the petitioner would still be at liberty to produce authentic documents to show as a proof of payment of forest royalty while procuring the goods, and accordingly the amount which is found entitled to by the petitioner would be duly released. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Para. The trust of the argument made on behalf of the petitioner is primarily based on the judgment, judgment dated so and so dated
33,
2017 passed in a batch of writ petition, including WPC 1, 2, 3, 4 of 2017. Full stop. This court had made an observation in paragraph 9 that apart from the preamble, there was no other clause regarding realization of forest royalty. Full stop. The subsequent judgment judgment dated 36/2022 in WPC 9227 of 2019 is with regard to the directions and consequential actions. Full stop. Para. A perusal of the facts and circumstances, including the documents, more particularly the part of the agreement which has been enclosed to the affidavit in opposition, would however show that under clause 38 of the, what is this?
Additional special conditions. Madam.
Additional special conditions.
Yes, ma'am. Page 130.
Additional special conditions, comma, there is a specific provision for deduction of forest royalty. Full stop. For any reference, he said clause is extracted herein below, page 133, clause 38. Wrong amount. In view of the aforesaid factual position, which is not disputed, now this court has noticed that the aforesaid condition is accepted by the petitioner whose signature appears in the document. Full stop. In view of such undisputed factual position, comma, this court is of the opinion that the observations made by this court in the order dated 33/2017 has to be held to be confined to the facts and circumstances of those cases and cannot be said to have a general application. Full stop. Para. In view of the observations and directions given by this court in the judgment dated 36/2022 in WPC 9227 of 2019 is based on the presumption that no such condition exists in the tender between the parties. Full stop. The facts in the present case are distinguishable in view of the specific clause as mentioned above. Para. In view of the aforesaid discussion and the factual position, comma, this court is of the opinion that the present challenge does not have any merit, and accordingly the writ petition stands dismissed. Full stop. However, as also agreed to by the learned standing counsel, the petitioner would be at liberty to produce authentic documents as proof of payment of forest royalty to make any claim for release of the forest royalty which have been deducted from the bills of the petitioner. Full stop. But this is of 2022.
Lord, we will give a time frame. Within 1 month, if you can.
Since the communication by which such request was made is of the year 2022, comma, in the interest of justice, a further period of a month is granted to the petitioner to make such claim. If claim, and if the same is done within the said period, comma, the same is to be duly considered by the respondent authorities in accordance with law.
Can it be 2 months, my lord, because I have to collect the all the
45 days.
45 days. Deeply obliged, Lordship.
No, পিছত মাতিব তেওঁ পঢ়িলো। Yes, Mr. Sharma. Prepared. Preparation over.
Verified, Lord. There is nothing in the matter. There is nothing. Actually, my remedy was in the civil court, Lord. If something is there. Lord.
That is what we are hinting. It's unnecessarily matter would be kept pending. So what do you do?
Lordship, if Lordship can grant me some liberty, because there is some delay that I cannot avoid. It is of the year 2017.
17, you are, it's already time barred.
Yes, Lordship.
We'll see if permissible under the law. Okay. Heard Sri R. Sharma, learned counsel for the petitioner. Also heard Sri B. Das, learned standing counsel, APDCL.
Yes, my lord.
APDCL. Full stop para. The present challenge is with regard to an order dated 6/9/2017, whereby the prayer of the petitioner for payment of extra work allegedly done by him has been rejected. Full stop. The petitioner had prayed for a review of the said order, which was also rejected on 18/11/2017. Full stop. Para. After hearing the learned counsel for the parties, it clearly appears that the present claim is based on certain facts which are required to be proved in the appropriate forum. Full stop. At the same time, Sri Das, the learned standing counsel of the department, standing counsel APDCL, has also submitted that the questions of fact are disputed in nature, which can be adjudicated only in a civil court. Full stop para. This court is of the opinion that the claim is based on certain extra works done by the petitioner, which can be proved only in a civil court by adducing evidence and giving the defendants a fair opportunity. Full stop. A writ court, not being a court on facts, would not be the appropriate forum for adjudication of such disputes. More so, such questions of fact, more so when those are disputed in nature. Para. In view of the above, the writ petition stands dismissed. Full stop. Liberty is, however, granted to the petitioner to approach the appropriate forum if permissible under the law.
Okay. Yeah, please, Lordship. Lordship, Lordship may kindly close the matters as the matters have become infructuous. Lordship may kindly come to the page number 164.
Which one?
In WPC now 7703 of 2022.
161.
Yes, 164.
164. Yes.
In the first paragraph, your Lordship, may I read?
Yes, please.
I am directed to inform you that on fulfillment of the provisions laid down in Rules 16 and 19 of Central Management.
Not central, control.
Control and Management of Ferry Rules 1968 as amended, the Governor of Assam is pleased to settle the Boduchar Basantapur ferry service with Abu Sayyid Mandal for the remaining period of 2022 to 24 with effect from date of taking over by the lease up to 31/3/2024 for rupees 53,98,650 rupees only on per year basis under the provisions of Rule 4(1) of Control and Management of Ferry Rules 1968 as
Yes.
amended. Yes, Your Worship.
You had
The period
challenged,
is-
you had challenged this.
No, the period is over, Your Worship.
So you had challenged this order
Yes.
in favor of the private respondent.
Yes, sir.
Now the period is over. Madam,
Well, also this matter has become infructuous.
you're for whom?
I'm for the respondent. I'm appearing on behalf of Miss MD Bora. She's in legs in court.
There is a
number one.
private respondent also. The settlement holder,
Yes, Your Worship, respondent number 6.
6. Has he appeared? No. What is your name?
SK Lahan on behalf of Mr. Azimura.
SK Lahon. And madam, your name?
A Saikia on behalf of Miss MD Bora.
Heard Sri SK Lahon. And what is the other matter? 6564.
Same matter, Your Worship.
Same.
Yes.
But petitioner is the same. Why two writ petitions? In that, what have you challenged in the other one? Heard Sri SK Lahon. Learned counsel appearing on instruction of Sri N. Bora
Yes, sir.
for the petitioners. Also heard Miss A. Sekya, learned counsel appearing on instruction of Miss M. D. Bora, then standing counsel transport department. You are also there, madam? Miss U. Das, learned state counsel is also present, para. The challenge pertains to allotment of ferry service. It however transpires that the period of settlement is over and therefore there may not be any live cause of action which requires adjudication. Para. In view of the above, both the petitions are closed. Interim order, if any, stands vacated. Silo. Okay. Yes, what is this?
Please, Lordship. Lordship, in this matter, I have received some verbal instructions from my client, Lordship. They
Not to
perhaps
press.
they might withdraw this petition, Lordship, although we have not received the
Doesn't
written
matter.
instruction.
What is
Lordship.
your name?
W. Rahman, Lordship, on behalf of Mr. Sharma.
Sri W. Rahman, learned counsel appearing on instruction. I heard Sri W. Rahman, learned counsel appearing on instruction of Sri E. Sharma for the petitioner. Also heard Ms. Hazarika for whom? Also heard Ms. You for BTC. Also heard Ms. U. Das, State Council. State Council's Ms. R. Sakya, learned standing council BTC. And Sri P. Hazarika, learned counsel for respondent number 7. Para. Sri Raman, the learned counsel, has however submitted that there are verbal instructions not to press this writ petition.
Lordship, we are praying for 1 week's time, Lordship, to get the final instruction, Lordship.
Not required. And he
Lordship,
prays for
that may
some
be
time.
considered, Lordship.
And he prays for some time to get written instructions. Para. The challenge was with regard to an order dated 7/11/2022, by which one incumbent was given permission to lift the monthly quota of PDS commodities by previous commodities. Para. The arrangement, the impugned arrangement appears to be a temporary one, and therefore there may not be any live cause of action which requires adjudication. Para. In view of the above, petition is closed. Interim order stands vacated. Mr. Laskar? J. Laskar? None appears for the petitioner on call, whereas the state is represented by Sri S. R. Barua, and State Council Para. Even on the last occasion, that is 11/3/2024, there was no representation on behalf of the petitioner. The petitioner, it appears that the petitioner is not interested to pursue this writ petition. Para, the same accordingly stands dismissed on non-prosecution. We're not saying anything on merits. There is a good case for cancellation of the vendor's license. The backside was not signed. Okay, we're not saying anything in absence. 10 and 11.
May please, Lord.
Yes.
Lord, in item 10, my lord, pleading has already been completed, my lord. The matter relates, my lord, in this proceeding, my lord, the petitioner has challenged the order passed by the commissioner GMC, my lord, whereby directed to remove the, my lord, motors from the, my lord, motorized rickshaws, my lord. Lordship will find the order dated 17/3/2023.
But is it alive?
Yes, my lord.
Yes, tell us the facts. We'll try to dispose this of.
No, we're pleading to do so. Lordship will find the
Lord, Lord, I am sorry, my lord, I am required to file a affidavit, my lord, rejoinder, my lord. Due
What
to
is
my-
there to decide? These are become
Lord, just a week's time, my lord, on next week, any date.
23 matter, argue and get an order if you have merits.
My lord, these motorized self-made rickshaws allegation is there, my lord, that we are violating the motor vehicle.
You are violating.
My lord. That is.
There
the
are
allegation.
orders from this court unless it is certified by the design by the IIT.
My lord.
We see anything flying on the road causing hazards. But will not be prejudiced by those. We
My
decide in accordance with law.
These are very.
In one of your cases, Mr. Bhuya,
My lord.
we had passed orders. We had given an interim order unless it is what Bahan? Deep Bahan or what?
Deep Bahan.
Unless it is Deep Bahan, you cannot. But you see anything is Deep Bahan nowadays.
Lord, now the Deep Bahan and our, my lord, rickshaws, my lord, is exactly the nature of same quality.
It
And
has to be certified.
My
There
lord.
has been so many accidents.
That's why, my lord, we have got certain, my lord, relevant papers, my lord, which I would like to bring on record, my lord. If my lord,
Not record, argue.
My lord can keep this as a part heard, my lord, on
Why?
next week.
We are keeping it for CSV.
Next week, any date,
We are keeping it reserved for judgment if we are not delivering it today, now.
my lord.
Argue, there's nothing.
My lord, actually, today I am a little bit underprepared also.
Mr. Sharma is there.
My lord.
By the time Mr.
Ma-
Sharma argues, he'll be prepared.
My lord, my senior can argue, my lord, but some time is required, my lord, to go from me. Due to my personal difficulty, my lord, that happens, my lord.
You're fit and sound.
No, my lord, no health is, other issues are there. my lord.
Other issues. Yes, when? Tuesday.
My lord.
Tuesday will dispose
Yes,
this
yes.
of.
27, my lord, I have some difficulty. Any date, my lord.
28.
Eighth, my lord, 20.
Okay.
20.
Heard Sri R. Sharma as well as Sri A. R. Bhuya, learned counsel for the petitioners in these two cases. Also heard Sri S. Bora, learned standing counsel, GMC and GDD and Madam Saikia for transport. Sharma,
Number 8.
Ms. Saikia for A. Saikia for transport department, comma, Sri R. Sharma for, who is he? Huh?
Manufacturer.
Manufacturer of the.
Respondent by it. For Ms. U. Das, Run State Council is present. Para. On a request made on behalf of the petitioners, matters are adjourned to be listed for admission hearing on 28, 28 তারিখ। No, 28 will do. 30 will be too late. 28.
Obliged.
Let us see what case they make out.
Obliged.
What is that?
Yes. May it please your lordship. On behalf of my standing counsel, as a leader, we want to withdraw this matter. Please.
You want to withdraw this?
Yes, lordship.
Okay. What is your name?
Edeka.
Edeka.
Yes, lordship.
Sri Edeka Learned Counsel appearing on instruction of Sri H. As a Sigdar
Yes, lordship.
submits that there are instructions to withdraw this writ petition. Forest Department, anybody is there in the court? Who was there? Forest, somebody was there. Is BDAS Forest Department? When BDAS? APDCL. Forester kon asile? RR Gogoi is he there? But he has to be there in the court. Also heard Sri so and so. Please get somebody. Standing counsel Forest Department. Para. In view of their first submission, the petition is dismissed on adjourned.
Obliged.
Huh? I bought her. Okay. Withdrawal, Mr. Bothagur. Item 14. Yes.
Made business. Lordship, the petitioner is a proprietor of a coal depot, lordship. Here, lordship, in this case, we are praying for release of my coal seized by the Mines and Minerals Department also. Lordship, we say that the search and seizure were itself illegal, because this was not done by following.
Mr. Borua, we can take this for disposal.
Otherwise, they have. Correction. And they have basically here, they have seven e-auction process.
So in that section, it has been specified when an order is passed, we can go for appeal or a review. In this case, no order has been passed. Directly my coal was seized. Thereafter, my notice was served. We have given reply. Then the coal was directly auctioned. It was not, even in the Mines and Minerals Act.
They have simply come against the e-auction.
Lordship, kindly look into my prayer. I have also prayed for the release of my coal. So the release, if the search itself is illegal, lordship.
Page 12 of the report.
Now, what has happened to the coal which was seized?
It has been, lordship, in my premises, it has been stayed by this honorable court.
No, that we have seen the order of stay. That notice was of 2024. We are in 2026. What is this present stage?
Still in my premises.
Coal. Mr. Barua, there is a stay order. The e-auction has been put to stay. Let us decide this.
Go ahead with the e-auction.
What do you say?
If the market value of the coal and the price which I will get from the e-auction, and lordship, without any fault of mine, first of all, they have to establish something I have done wrong, lordship. Lordship, if your lordship looks into the act itself, section 22 says that they have to follow the due process of CRPC. Section 100 of CRPC, section 100
Okay,
says.
let us proceed with the case. What is it? Please narrate the facts.
Mines and Minerals Act.
You are H. Agarwal.
H. Agarwal.
Yes, what are the facts?
Page 41.
Hold on.
Of the facts is, lordship,
Please narrate the basic facts.
Lordship, the petitioner is the proprietor of a coal depot. The proprietorship firm or the proprietorship concern of MS East India Trading. Lordship, he is running his business with all the requisite documents. Lordship, may look into the documents. He is holding Assam Panchayat Act.
Okay, okay. You have all the documents.
Yes, including the Mines and Minerals Act
Okay.
from the Mines and Minerals Department. Lordship, may first look into the Annexure 6 at page 27.
27.
27. It was given to the landowner by the subdivisional officer civil marketer. If I may read, Lordship, the notice was given. It has been observed that coal is stored in your premise. As per our survey, a total of 1 biga 0 kattha 0 lessers bearing dark number so and so at Tipongpani, Notungaon near firing range is used for storing coal. Upon assessment by the CIL authorities, 1581.39 metric cube approx coal is stored within your premise as on 28 June 2024. In this regard, you are directed to submit details of your land, source of the coal stock, relevant licenses, and other relevant documents within 3 days. Until the matter is resolved, you are directed
Who
to.
is this Bitul Sakya?
Bitul Sakya is the owner of the land. I am the lessee. It was served upon my after the coal was seized on the same day. Thereafter, Lordship may turn to page 29, the reply given by Sri Bitul Sakya to the subdivisional magistrate Margeta subdivision PO Margeta, your letter number so dated 28/6/2024. Submission of documents regarding. In response to your above reference letter, I hereby submitting the following below mentioned document in respect of land and source of purchase. I further would like to inform you, your good self, that I am absolute owner of the plot of measuring 7 biga 2 kattas 10 lessons under DAG number 127 covered by periodic patta 21 situated at Tipongpani, Notungaon, Mojatira. Out of said land, a plot of land 2 biga has been leased out as storing of coal by Sri Akajyoti Kaur, the petitioner herein, proprietor East India Trading to store coal therein. As regards source of coal stockist, it is informed to by Sri Akajyoti Kaur, proprietor East India Trading, that the same was duly purchased coal from C. Longyamphong, Longlang, Nagaland and others. Please acknowledge the receipt of the same and enclosure, Lordship, the land document, lease agreements, trade licenses, consent to establish NOC, all the documents, even GST registration, my Udyam registration, acknowledgement of the receipts, everything was given as an enclosure, Lordship. And the Annexure 8 series all are the invoices of the coal, Lordship. All the invoices of the coal. Lordship, thereafter,
This Udyam registration is in your favor. So while responding to the notice by the owner of the land, he has also given your documents.
all my documents.
Okay. Thereafter,
Thereafter, Annexure 9 will Lordship will find that an action taken report was regarding the verification of the coal depots in Margherita, Lordship. And this ATR summary has been given in page 71 at serial number 5. My coal has been mentioned there. At page 71, serial number 5, there has been there my reply was also given. And
page
71. Starts from page 70. It has been
what is this?
addressed to the senior geologist by the subdivisional officer civil Margherita. These are some action taken report on verification of the coal depots in Margherita. And the next page, ATR summary of coal depot at serial number 5. Tipongpani Notungaon nearing firing range. The owner of the landowner's name is mentioned here. And my reply was also has been mentioned and documents.
Serial number?
Page 71. Serial number 5.
Yes.
Here, Lordship may see, location, Kipong Pani, my location has
Yes, we
been,
have seen.
landowner's name has been mentioned.
Hmm.
And my reply has been, what I have replied, and my document submitted has also been reflected. here,
Yes.
Lordship. Thereafter, Lordship, then e-auction was held on, 18/12/2024, which has been stayed by the Honorable Court. In regard to my call, all other call has been auctioned now. Only because of the stay of this Honorable Court, my call has been stopped. The Lordship may look into, after going through this document, Lordship, my call was seized without giving me.
When was it seized?
It was seized on 28/6/2024. On the same day, notice was issued to me.
Same date the notice was issued to the owner.
Owner.
Okay.
Also, I would like to draw your attention to the Mines and Minerals Act, section 22B at page 41. Also. The same book, I think.
This
23.
book, you're carrying this book?
Yes,
Page
41.
41.
Oh. The bottom 23B, power to search. May I read?
Yes, please.
If any gazetted officer of the central or a state government authorized by the central government or a state government, as the case may be, in this behalf by general or special order has reason to believe that any mineral has been raised in contravention of the provisions of this act or rules made thereunder, or any document or thing in relation to such mineral is situated in a place or vehicle, he may search for such mineral, document or thing, and the provisions of section 100 of CRPC shall apply to every such search.
Yes.
Okay, now I want to turn to read section 100 of the CRPC.
Then give it to the CRPC. Yes. Yes, please.
Whenever any place liable to search or inspection under this chapter is closed, any person residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant, and on production of the warrant, allow him free ingress thereto and afford all reasonable facilities for a search. Or if the section itself, in section clause 1 only, the warrant is required in section 100. If ingress into such place cannot be also obtained, the officer or other person executing the warrant may proceed in the.
No, you have to read the entire contents as a
Yes.
whole. Whenever
Yes.
any place liable to search or inspection under this chapter is closed. So that is the precondition. First, the premise is closed. Any person residing in or being in charge of such place shall, on demand of the officer or other person executing the warrant, and on production of the warrant, allow him free ingress. You want to contend that there is a requirement of a warrant.
Warrant in section 165 of the CRPC also says that warrant is to be there. I will come to that point. Lots of other points are also there in this sub closing. So, point number 2. If ingress into such place cannot be so obtained, the officer or other person executing the warrant may proceed in the matter provided by subsection 2 of section. Point number 3. Where any person in or about such place is reasonably suspected of concealing about his person any article for which search should be made, such person may be searched, and if such person is a woman, search shall be made by another woman. This is not required. Now, 4. Before making a search under this chapter, the officer or other person about to make it shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or any other locality, if so such inhabitant of such locality is available or is willing to be a witness or to the search, to attend and witness the search and may issue an order in writing to them or any of them. So in this case, no Panchnama has been prepared, no any witnesses has been, witnesses signature has been obtained, no any Panchnama has been given to us also, which is a requirement in subclause 6. I will come. Next 5, the search shall be made in their presence and a list
Okay,
of.
we have understood. You say that there is violation of section 100 of the CRPC. And there is a requirement to meet meet all the
Witness.
formalities of section 100 as specifically mentioned in 23B.
23B of the mines and.
Okay.
This is the main ground report, and the notice was issued after the seizure was made. If they would have been, and they could have sent me the notice.
Mr.
prior to
Barua,
seizure.
what procedure did you?
Lordship, first
undertake?
of all, Lordship, the now what his submission is that regarding the search and seizure.
Yes.
But from the pleadings of the writ petition, no, not at all averment is made in the writ petition and the prayer also. And Lordship, in our affidavit, we have stated.
But these are
that
pure
petitioner-
questions of law. If there is a requirement to follow section 100,
Lordship,
that's in the prayer, but still that since you have raised this issue.
yes, yes.
Please, I think 12 or 11. 12,
11.
11.
Starts from page 11.
Yes, 11. Release the stock, stay the execution. To release the stock, cold stock. Have you said anywhere the search, the seizure is bad in law?
No way,
Mr. Agarwal?
nothing.
What is your pleaded case? What are the grounds of challenge?
Okay, my grounds of challenge I have mentioned in this, in my submissions also.
Where?
That they have, it starts from para 7 also,
7.
page 8.
Principles of natural justice. Eight, you have made something very vague, but still that.
Lordship, one I would like to point it out. In our affidavit, we have said the petitioner has failed to erect such some signet at the site of the stockyard. That's why the notice was issued to the landlord. And Lordship may now come to page, Lordship, 21 of the writ petition, Lordship. It's very interesting because that seize was made on 28/6/24. These
Page 21.
Yes, page 21 of the report, and it's a 3, Lordship.
It is the
This
license.
license was issued from the period 1/7/2024. It was subsequently obtained, Lordship.
The
The-
previous
the-
license is also there. Not the case that I
License
have.
17
1/7/2024.
to 36/25.
And Lordship, now Lordship come to page 25, Annexure 5, Lordship.
Where is your previous license?
Lordship, I may produce.
No, the license
It is
for
the
the.
review, Lordship, it is the period is mentioned here. It's from 1/7/24 to 36/2025.
Yes.
Since this petition was filed, so maybe it's on 13/12/2024. That is the reason they have given the present at that time. Which I think.
Because they have
I
also
can
come in
produce the previous license.
Lordship may now come to page 25, Lordship, Annexure 5. Some license. Page 25, Annexure 5, Lordship. Serial number 13, Lordship. Number and date of application of this registration. Lordship may kindly see the date, 8/8/2024. All are subsequent to the seizure, Lordship. Page 25, Lordship, serial number 13. And they have approached before the court in the month of December 2024. And seize was made on 28/6/2024, Lordship.
But first you had shown us 21, then which next page?
25, Lordship. Page
This-
25, Annexure 5.
This is one permission
Yes.
by the mines and the minerals.
Yes. Lordship, serial number 13, Lordship. Under the column of number and date of application of this registration. Eight 2024. And Lordship, we have also stated in our affidavit that the petitioner has failed to show the proper e-way bills as per, which is required as per the rules, Lordship.
Where have you stated?
Paragraph 7 of our affidavit in opposition, page 92, Lordship.
Yes.
And Lordship, I have annexed that Assam Mines, Assam Minerals Regulation and Dealers Rule 2020, page 97, Lordship. In along with my affidavit, Lordship. Lordship may come to page 102, Rule 12, Lordship. Appeal provision. May I read, Lordship? Any person aggrieved by an order of a competent officer for a particular action under these rules may, within 30 days from the date of communication of the order, prefer an appeal in form.
Page definition,
page,
rule?
Rule 12, appeal. 102 page.
File in the book also, page 37.
Yes.
Yes, that appeal, Lordship. Any person aggrieved by an order of a competent officer for a particular action under this rule may, within 30 days from the date of communication of the order, prefer an appeal in Form J to the Secretary of the Mines and Minerals Department, Government of Assam. And there is another provision of revision, Lordship. 13, Rule 13, Lordship. Any person aggrieved by an order passed in appeal under this rule may file an application for revision before the senior most secretary, Mines and Minerals Department, within 30 days from the date of communication of such order in Form K. The alternative remedy is very much available, Lordship. And from the two documents I have showed, Lordship, the region that they have failed to produce the documents, and all these documents were procured subsequently. They have not annexed the prior documents. We don't know, Lordship.
But the appeal has to be preferred within 30 days.
Yes, Lordship.
Now, this repetition was instituted in the year 24.
Yes.
The 30 days is over long back.
And if your Lordship may give any direction regarding that condonation, they may prefer it.
I may support.
Anything else?
Lordship,
This affidavit has been replied to by the petitioner.
Yes.
Yes, yes. They
What
have also given reply.
What have they said?
Regard to para 7, para 7, we have replied regarding the e-way bill also. The e-way bill is not required when the goods, good amounting to rupees less than 50,000 in a bill. Lordship. The bills are of, all the bills are of less than 50,000. In terms of rule 138 of.
See, why haven't you, in the reply affidavit, have you stated anything regarding the license in that relevant period? Have you stated anything? You have not enclosed the document, that is, we have seen. But have you stated in the readings the period that you had a valid license during the relevant period?
So even if I do not have license, if your Lordship looks into the rules again. Of the Mines and Minerals license, they are talking about, right?
If your lordship may kindly turn to,
Then in what capacity are you storing coal if you do not have a license?
lordship, the dealership license for if the end user consuming 500 MT or more per annum of commercial purpose. If I consume more than 500 metric ton per
How
annum,
much is the amount involved?
lordship, I am only claiming 400 ton.
400 ton.
Yes,
For what purpose?
my bill are of 400 ton.
No, no, what do you, how do you, why do you use 400 ton? Where do you use that? It's not for business.
For business purpose.
No.
Maybe, but it's not more than, I'm not consuming more than 500 ton per annum, lordship. If a license, dealership license is required only for the consumer, only for
Then
the.
why did you hurriedly obtain a license immediately thereafter?
Lordship, maybe the application was filed, I do not know, but the maybe.
No,
the
see,
application was
see,
filed
Mr.
earlier.
Agarwal, we are exercising writ jurisdiction, it's an equity jurisdiction.
They
In the
have
writ
not
proce-
stated in the affidavit regarding the
Mr.
license.
Agarwal, just have the patience.
Yes.
In the petition, there is nothing with regard to you have annexed license, but both the license as well as the permission by the department is of subsequent dates. You have made an oral submission that these are extension. So in your reply, you ought to have at least, if not the documents, you should have annexed the documents. If not done, at least make the amendments.
They have not objected to my license in the affidavit in opposition also.
It has been pointed out, license, are we
They have
not
not pointed
entitled to
out.
see the date of the license? License validity is of the which period? The period where the cause of action has arisen. Now, both the documents which you have relied upon are of subsequent dates. You may have
Maybe
we are not saying you do not have, but you should have mentioned at least, you have not done.
Yes, lordship, I will bring it on record,
You can bring it on record in the appeal, we'll dispose this off. You'll have a better, in fact, avenue to place all the documents before the appellate authority. We'll fix a particular time. And since you are protected by an interim order, we'll say that till consideration of the appeal, if this order will remain, and they'll decide in accordance with law.
They have not passed any order only.
It's not required. You can state your grievance before the appellate authority. There may not be an order, but you are aggrieved by the seizure of the goods.
They have asked for a reply, we have replied. They have given us the notice, we have replied, the landowner has given the reply also, but.
See, that notice was not put to you. That was on the landowner, and there was no hoarding which Mr. Barua has said. Now, in this proceeding, the position has become clear that you are a leaseholder and you are stocking coal on the basis of certain license which you claim and permission also. You can produce all this before the appellate authority. You may have a previous license. It may be a mere extension. And if in an extreme case, if you want to justify that even without a license, I am entitled to stock this much of coal, you try to convince the authorities. Okay. The instant writ petition has been filed with the following relief. Petition under 2016, with the following page 11, para. The grievance, the projection, the facts as projected in the writ petition is, in brief, is that the petitioner is the sole proprietor. Please have your seat, Mr. Baru. Sole proprietor of Messrs East India Trading, which operates a coal depot in the district of Tinsukia, for which the coal is processed into coke for distribution in the country. Full stop. The petitioner claims to be registered under the GST and is also in possession of necessary licenses, including the approvals from the Assam Panchayat Act, Pollution Control Board, and Department of Mines and Minerals. Full stop. However, the coal stock was seized on 28/6 2024 without prior notice or by following the due process. Full stop. On the same date, however, a notice was issued to the landowner who had submitted his response on 2/7/2024 by furnishing all the relevant documents. Full stop. It is submitted that relevant document. However, no action has been taken. Full stop. This court, while issuing notice, by order dated 17/12/2024, had passed an interim order that the e-auction notice issued in the meantime should not be acted upon. And that interim order is operating. It has been extended from time to time and is in operation. I've heard Sri H. Agarwal, learned counsel for the petitioner. I have also heard Sri S. R. Barua, learned state counsel, appearing on behalf of all the respondents. The learned counsel for the petitioner has submitted that the petitioner is a leaseholder over the plot of land from which the business is being run, and he is in possession of all the necessary permission and license. Full stop. The learned counsel has, he has drawn the attention of this court to the license issued by the concerned Gao Panchayat and also the permission by the Department of Mines and Minerals. He has submitted that all other formalities are being duly fulfilled by the petitioner and the impugned action is grossly illegal. He has also drawn the attention of this court to rule not rule, to section 23B, 23B of the Mines and Minerals within bracket Development and Regulation Act 1957, which is with regard to power to search. He has highlighted that there is a requirement for compliance of the provisions of section 100 of the CRPC while making such search, and the said provision of the CRPC has been grossly violated. Full stop. He has also submitted that the impugned action is not backed by any is not supported by any law, and the same is required to be interfered with, as it impedes the right to have a fair business in accordance with law. Well, per contra, Sri S. R. Barua, the learned state counsel at the outset, has submitted that the act in question provides for, not act, that the statute holding the field provides for referring an appeal as well as revision. In this regard, he has drawn the attention of this court to the Assam Minerals Regulation and Dealers Rules 2020, page 97. So, more particularly, Rule 12 and 13, which relate
which provide, which relate to preferring of appeal and revision by an aggrieved party. Full stop. Pero, on the merits of the case, the learned State Council has submitted that though certain documents have been put on record by the petitioner in support of his claim, those documents are not relevant, full stop, by specifically referring to the license by the Gaon Panchayat. The Learned State Council has submitted that the period has been mentioned from 1/7/2024 to 36/2025, whereas the impugned action is of a prior period, prior date, which is 28/6/2024. He has similarly drawn the attention of this court to the permission granted by the Department of Mines and Minerals, which is based on an application dated 8/8/2024, as would appear from serial number 13 of the said permission. Full stop. By drawing the attention of this court to the affidavit in opposition filed by the respondent number 4 on 10/6/2025, more particularly the averments made in paragraph 7 of the same, the Learned State Council has submitted that there are no e-way bills to justify the business and transaction of the petitioner. Full stop. He submits that the petitioner is not entitled to any equitable relief from this court. Para? Sri Agarwal, in his rejoinder, has, however, submitted that though the license, though that the effective license at the time of filing of the writ petitions were put on record, and there would be previous documents to show that the business of the petitioner was run on a lawful basis. Full stop. He has also submitted that the requirement of e-way bills would be there only when the magnitude of the business is of a particular amount, which, and the business and the
Invoice of a particular invoice is.
particular invoice and the amount involved with the business of the petitioner is less. You said
But so
500.
in the invoice is less, the invoice bill amount is less than 50,000 per
Yes,
invoice.
yes. And the bill amount is less than the stipulated amount. Para? The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Para? The pleadings in the petition have been perused, and apart from a vague assertion that there has been violation of the law, there is no reference to any of the statute, including section 23B, which of the act, which also refers to section 100 of the CRPC. Full stop. However, those big questions of law, the petitioner would not be precluded from raising those points in support of his case. Full stop. At the same time, the jurisdiction exercised by this court under Article 226 of the Constitution of India is equitable in nature, wherein the petitioner, wherein the party approaching this court has to prima facie make out a case of his bona fide. Full stop. Para? Both the license issued by the Gaon Panchayat and the permission issued by the Department of Mines and Minerals are of subsequent period, which have been mentioned above, whereas the impugned action is of a prior date, that is 28/6/2024. Though the learned counsel for the petitioner has submitted that there would be previous permission
of the concerned period, no such averments have been, not to talk about any documents been enclosed to the rejoinder affidavit, no such averments have also been made, full stop, para. Without going further into the issue, this court is also of the opinion that questions of fact are involved in this proceeding which are disputed in nature, and the rules of 2022 clearly provides for an appeal, full stop. Sri Agarwal, the learned counsel, has expressed an apprehension that in absence of any order passed by the authority, an appeal may not be entertained, full stop. This court is, however, of the opinion that a grievance has been raised by the petition, that the grievance which has been raised by the petitioner in the instant writ petition can very well be raised before the appellate authority, who is empowered under Rule 12 to entertain and adjudicate such appeal in accordance with law. This court has also noticed that Rule 12 prescribes a period of limitation of 30 days, which has expired long back, full stop. However, considering that this writ petition was filed immediately after the cause of action, and there is also an interim order operating till date, interest of justice would be served if the appeal, if so filed by the petitioner, is directed to be entertained by the appellate authority without going into the aspect of limitation, full stop. The writ petition accordingly stands disposed of by directing the petitioner to prefer an appeal within on or before today's 22nd, on or before 15th of 13th of February 2026, and if the same is done, the appellate authority shall not insist on any further application for condonation of delay or for explanation of the delay, full stop. The appeal is to be decided on its own merits by taking into consideration the facts and circumstances, full stop. In the adjudication process, the appellate authority is required to give the petitioner an opportunity of hearing, and the decision taken is to be in the form of a speaking order, which is required to be communicated to the petitioner in accordance with law. It is provided that till such appeal is decided, the interim order passed by this court would remain operative.
They would file this 15th and.
No, we have only said.
Lordship, I think next item we file a affidavit.
We'll come at 2 o'clock.
2 o'clock, I am having a matter habeas corpus.
Somebody will be there at 2 o'clock.
Yes.
May I please have a- The Lordship, I have to file an affidavit in reply against the private respondent's affidavit. Their respondent number 5.
You're for?
I appear for ONGC.
Okay. Who's filed?
Our pleadings
Pleadings are
are
complete.
from our side, pleadings are complete.
ONGC
You are
pleadings-
the beneficiary.
Yes.
You have filed your affidavit.
Yes.
You need to respond.
Yes,
Then is there an interim order?
no.
How much time, Mr. Sharma?
I'll file it in today or in course of the day, or
Okay.
maybe on the reopening.
Okay. Heard Sri R. Sharma, learned counsel for the petitioner. Also heard Sri I. Chaudhary, learned senior counsel, assisted by Mr. P. Barwa for the ONGC, and Sri Alan Dihinya, learned counsel for respondent number 5. Full stop. While pleadings have been completed, completed for the qua the official respondents, Sri Sharma, the learned counsel for the petitioner, space for some time to file a rejoinder affidavit to the affidavit in opposition of the respondent number 5. Full stop, para. Let such rejoinder be filed. Para. Let this matter be listed when?
5th of February.
5th of February. That matter, as agreed to by the learned counsel for the parties, please let this matter be listed on 5th of February.
Obliged. Wait, please. Your Lordship.
Yes.
My lord, this writ petition has a background. In 2022, my lord, the cattle market was settled by tender.
Yes.
After that said period, my lord, after 2023, my lord, in 2020.
It was settled with you. The cattle market was settled with you.
In 2022-23 period.
What was the tenure?
22-23.
Yes.
In 2023-24, my lord.
Yes.
Again, tender was invited.
Mm.
Subsequent period. When tender was invited,
Yes.
I was ready with all papers to file tender. In the meantime, my lord, the BDO who called for the tender refused to accept my tender.
Yes.
Taking the plea that the superintendent of police issued a letter not to settle the cattle market.
Yes.
Being aggrieved by that order, my lord, I came before your lordship.
Earlier.
Yes, my lord, in 2023.
Yes.
And your lordship passed an order on 26/6/2023, that is at page 39.
26?
26/6/2023.
Yes.
That is at page 39.
39.
39 to
Yes.
42.
Yes, please.
So, my lord, I am going to operative portion at page 41. Accordingly, from the provision of section 7, 8, 10 of the Assam Cattle Reservation Act and notification dated 25/5/2000 bearing number so and so issued by Principal Secretary
That
of
is suspended. We have read this. Till the next date, the order is suspended.
Yes, ma'am. Suspended. Order was suspended.
Yes, thereafter.
And now the position is this, my lord. Order was suspended. Tender was not accepted. Order was suspended, but it was the authority of the BTC to accept my tender. They did not accept the tender, but I ran the market for 23-24. 23-24.
You run.
I ran, my lord. Because, my lord, neither they
You
accepted.
ran the business on the strength of what?
My lord.
On what strength?
Because, my lord, I was ready with tender. Tender was not accepted, and
On the strength of being the earlier lessee.
my lord. Yes.
Like
On
you,
the
there were.
I am earlier lessee. I
That
was ready
is
to
different. Otherwise, there may be many like you.
Yes.
Who were ready to participate. They were not given, but since you are the sitting lessee.
Yes, my lord.
Your thing was
I
extended.
ran the market.
Okay.
They did not interfere also.
Okay.
I was running, my lord. But in recently, when 2020, 26, my lord, this 25-26 period. 25-26 period, there is a no settlement is invited again, my lord. No
Yes.
tender was called for. So, my lord, my humble submission before your lordship, my prayer may be looked into it.
Yes.
At page 10, my lord,
Yes, we have seen this. To call for tender.
that call for tender for the market, because it is a market for which in 2023 tender was called for. Now the government is not calling for the tender, so
Yes, who is for BTC?
What we have actually received the instructions and we have filed an affidavit accordingly. Lordship, in its earlier order, it has raised two specific queries. Firstly, whether a cattle market can be permitted to run without any tender process for the period in question. Secondly, the court sought instruction from the respondents as to why the year 2025-26 there has been no initiation of tender process. Lordship may come to page 55 of the affidavit.
Yes, please.
It has been categorically stated that the tender for the Barimaka cattle market had been stated on such and such date. However, a letter such and such from the Office of Superintendent of Police, Baksa, whereby the cattle market was cancelled in the district of Baksa as it shares an international border with Bhutan, as it is specifically mentioned in Assam Cattle Preservation Act 2021. As per section 3, clause 2, that may I read, Lordship? No person shall transport or offer for transport or cause to be transported any cattle from any place within the state of Assam to any other place in a district within the state which shares international border with any foreign country. The slaughter whereof is punishable under this act. Further, Your Lordship, this petitioner has been running the market illegally and collecting tolls from the Barimaka cattle market illegally, as no tender process for the same has been initiated by the BTC authorities.
Okay, presently it is not, the market is not there.
Market is there, but it is occupied by the petitioner.
No, if you say that the location is strategic, which will not permit a cattle market to be operated.
That's why tender process is not initiated.
Understood, then how is the petitioner running? You initiate a process of tender in 2022-23, he is settled. Next year you do not initiate, you may have good reasons, which you have indicated. Now, in spite of that, he keeps on running. Now he's asking for a tender process. You said that it cannot be given on auction because it is strategically located. There is a rule. Now, if there is a rule, why is he being allowed to run?
Need to seek instructions for that, Your Lordship.
Mr.
My lord, my humble submission before your lordship.
If
that
there are
tender-
statutes.
Without tender, nobody can run. But thing is this, it is a market to be settled. And your lordship said,
No, they have stated a statute as per which if it shares the international boundary.
that has been answered by your lordship.
Where?
In the order, my lord, I refer to.
Where?
Yes, it is said that no authority can stop the market.
Where?
Yes, my lord.
Which?
Your lordship. Your lordship, I have already, page 39.
39.
Yes, ma'am. What has been referred by my learned friend, my lord, that was challenged in the writ petition. That was challenged by the writ petition. And your lordship observed that the superintendent of police has no power. And after going through the secretary's letter, my lord, bearing number so-and-so by the principal secretary, Govt of Assam, political beat department, it is seen that superintendent of police has not been empowered to direct the principal secretary BTC to cancel the cattle market. They cannot. Superintendent of police has no power. But they, in the affidavit, it is said that superintendent of police, on the basis of superintendent police, that tender process has been cancelled.
No, okay, superintendent of police does not have the power.
Power, yes.
But where is the right of yours?
No, my lord, I do not claiming any right. My thing is this, my lord, why they are not settling the market?
No, there is a law.
My lord.
That cattle markets cannot be there in a strategic location which shares with the international border.
No, my lord, it is for slaughtering, not for settling.
Let us see.
No, my lord, it is for selling.
Yes.
Purchase and sale of the cattle, not for not for slaughter.
Understood. What is the law? Let us see
The
again.
law we will look into, my lord.
Let's see.
Otherwise, my lord, in 2022, how they?
There are some mistake done, but doesn't mean
My
no
lord.
person shall transport or offer or transport or cause to be transported any cattle from any place within the state of Assam to any other place which shares internal with a foreign country to slaughter, whereof is punishable under this act.
Slaughtering
Slaughtering is punishable in Bhutan.
My lord.
Slaughter is punishable in Bhutan. So therefore, transportation of cattle in those areas, strategic areas, is not permissible. It has got nothing to do with the slaughtering in India.
Well, in that case, my lord, my humble submission will be that if they do not invite tender for the market, if they do not,
Mr. Sheikh, we cannot force them to have a market which
My
is not permitted
in
by
that
law.
case, my lord, my prayer before your lordship,
Yes.
there is a sense of establishment. What is the real fact, my lord? Because earlier that one party running the BTC, so we were favorite to them, my lord. So we collected the tools of with the market without any interference from the
Mr. Sheikh,
administration.
this submission of yours is not acceptable because it is not the case that not giving to you some other persons have been granted.
No, my lord, that is the case, my lord.
If
Listen,
you make
now
out a case,
what now what happened?
that only to oust you, somebody else has been
My
sought to
lord,
be favored,
now-
then we interfere.
Yes, sir. Now your lordship, what happened? There is a sense of establishment. Now Hagrama has come into power.
We are not
I'm
concerned,
too-
we are not too concerned, we don't make those kind of
My lord,
submissions.
my lord,
You make those kind of submission where you make out a case,
my lord.
where to just to make it.
I was not allowed
And
somebody.
somebody else's, then you, this is.
Yes, my lord.
Okay.
I will come.
Heard. 3 M.A. Sheikh, learned counsel for the petitioner. Also heard your name. Amit. Amit Bhaiya, learned counsel appearing on instruction of Sri A.K. Bhaiya, standing counsel BTC. Yes, anybody else? Also heard Miss U. Das, learned state counsel, and Sri Ghosh, what Ghosh? A.K. Ghosh, A.K. Ghosh, learned counsel appearing on behalf of Sri S. Datta, standing counsel PNRD. Para, considering the facts and circumstances, including the stand of the BTC in its affidavit filed on 7/1/2026, this petition is taken up for disposal at the admission stage. Mr. Sheikh, please have your seat.
My lord.
Tara, as per the facts projected, the Bori Makha BRSLO, cattle market was settled with the petitioner for the year 2022-23. First of though the period of settlement was for a year, the petitioner claims to have been running the market and collecting tolls. Full stop. However, for the year 25-26, no tender has been invited. Full stop. The petitioner claims to have filed representation on 19/11/2025, which was not taken into consideration. Full stop. Accordingly, the instant petition has been filed. Para. Sri Sheikh, the learned counsel, has drawn the attention of this court to an order dated 26/6/2023, passed by this court in an earlier proceeding dated 3/7/47 of 2023, whereby this court, while issuing notice, had stayed a communication dated 9/6/2023 issued by the Superintendent of Police Baksa, whereby the Superintendent of Police had directed the Principal Secretary BTC to cancel a tender process for settlement of the market in question. Full stop. This court had raised, this court had made an observation with regard to the competence and jurisdiction of the superintendent of police to issue such a direction. Full stop. Para? Sri Sheikh, the learned counsel, has submitted that only because there is a change.
Only one point, my lord, if your lordship permit. That page 55 of their affidavit, my lord. That transport or offer of transport or cost to be transported any cattle from any place within the state of Assam to any other place in the district within the state which shares international border with any foreign country. The slaughter whereof is punishable under this act. My lord, in Bhutan, there may be prohibition, but Cattle Preservation Act cannot be made punishable that in Bhutan, it is not permissible. This is not the law. Law is this, my lord.
That is not a correct interpretation, Mr.
My
Sheikh.
lord, my lord.
It's a question of fact whether cattle slaughter is permissible in Bhutan. It's a punishable offense.
No, but- no,
You are not saying that laws in India had made it punishable.
no, my lord. Cattle, that is not, my lord, subject to correction by your lordship. Assam to any other place in the district within the state which shares international border. All right, my lord.
With a foreign
With
country,
any
the
foreign country.
slaughter whereof.
Slaughter whereof is punishable under this act. My lord, our act cannot be make offense in Bhutan punishable, my lord. Our law will be punishable
Yes,
here only.
last year, sir. A change in regime, comma, the impugned action has been taken so as to favor some other persons of their choice, of the choice of the present regime. Para? So, per contra, comma, Sri Bhuya, the learned counsel representing the BTC by referring to the affidavit in opposition filed on 7/1/2026 has submitted that the Assam Cattle Preservation Act 2021 itself contains a provision for not having any business relating to cattle transportation in any district of the state which shares international border with any foreign country, the slaughter whereof is punishable under the act. Full stop. He has submitted that though the superintendent of police had issued the communication dated 9/6/2023, comma, irrespective thereof, comma, the law holding the field would not permit for allowing the prayer of the petitioner. Full stop. Para? The learned counsel for the other respondents have also endorsed the view that endorsed the stand taken by the BTC authorities. Para? The prayer in this writ petition reads as follows, page 9. The same is with regard to a direction for issuing NIT for settlement of the market in question. Full stop. The affidavit filed by the BTC on 7/1/2026 would, however, show that it is as per section 3 within bracket 2 of the Assam Cattle Preservation Act 2021, for which no action for settling the market has been taken. Full stop. For any reference, comma, the relevant amendments made in paragraph 5 are expected herein below. Full stop. This court has also noticed that there is no denial to the aforesaid proposition, which is purely based on the provision of the Act of 2021. Full stop. Para? It is a settled position of law that no mandamus can be issued for an act which is not permissible in law, as it is the primary duty of a litigant approaching the court to make out an enforceable right. Full stop. In the instant case, not to talk about any enforceable right, comma, the prayer made appears to be in conflict with the law holding the field, full stop. At this stage, comma, we say the learned counsel for the petitioner has submitted that the culpability of cattle slaughtering, which is as per the Act of 2021, cannot be made applicable in Bhutan. Full stop, full stop. This court is, however, unable to accept the said submission in as much as the language of the statute is clear, and it is also not in dispute that the district in question shares an international border with a foreign country, that is i.e. Bhutan. Full stop. In view of the above, comma, this court is of the view that no relief whatsoever can be granted to the petitioner. Full stop. The petition is accordingly dismissed. Yes.
Obliged.
Twenty-four. Supply. None appears for the petitioner on call, whereas the Public Works Department is represented by its standing counsel Sri B. Gogoi Para. In the interest of justice, matter is adjourned to give the petitioner another opportunity to represent Para. List on 9th of February.
Well, in this matter, my lord, the affidavit was supposed to be filed, my lord. It has come after waiting, my lord, today only.
Okay, you
No.
filed the affidavit.
I'll file, my lord.
Heard Sri Bodloy. Learned counsel for the, you are not there on record, Mr. Bodloy?
Lordship, no, Lordship.
Learned counsel for the petition. Mr. Para. Also heard Sri H. Gupta, learned CGC, who has submitted that the affidavit in opposition is ready and would be filed shortly. Full stop. He accordingly placed for some time. Para. Considering the above, matter is adjourned to be listed on 11th of February, by which time the affidavit in opposition is required to be filed.
Lordship, can it be on Lordship 25? My senior will not be available. on the 25th, Lordship.
Of February.
Lordship.
Okay. Then don't say as as a last as agreed to by the learned counsel for the parties, list on 25/2.
Lordship. Oblige you, Lordship.
Yeah, please, Lordship, I have received the communication, Lordship. Here, Lordship, the current incumbent, Lordship, he is asking for some time, Lordship. I have a letter because he was never served with the notice regarding the contempt.
Contempt matter, okay.
Yes, Lord.
Okay,
2009.
Sri H. Aliya learned counsel has submitted that the present incumbent holding the post has come to know about the order recently.
Yes.
And he prays for some time to make his response.
Lordship, here, in order to release the salary, Lordship, with humility, Lordship, the concerned officer has asked for 3 months' time because a proposal has to be sent them supplementary.
And he has prayed for some time to take appropriate action for compliance of the order. Full stop. Para. He has also submitted that as per instructions received by him the matter has been moved.
No,
And-
Lordship, now they're getting the 2019 records.
Were moved and
Being
a
scrutinized.
period of 3 months' time has been paid for. Para, considering the facts and circumstances, matter is adjourned. To be, which is, and adjourned to be listed on, we're not giving 3 months, on 27th of February.
Lordship.
On which date up-to-date instructions
Lordship.
are to be placed on record.
Lordship.
Similar matter is pending of the same content by your lordship. Lordship, if since required 3 months,
Why not give it 3 months? 27th February, we are saying.
lordship, at least we can get the instructions. lordship.
That is-
The amount is a very small amount.
That is what we are saying, 27th, he'll give up-to-date instructions, okay? 27th February. Redressed. No, you said last time,
Yes, Lordship.
has it been redressed, madam?
Lordship, the issue has been resolved, your Lordship, and we have filed the appeal electronically.
Okay.
Lordship, may extend the time to file.
Filed by hard copy.
Lordship, we were informed by the department that they will consider the appeal only after the extension of the time to file the appeal.
Okay. Now you'll file electronically or by hard copy?
Filed electronically, and we have also submitted the.
Okay, you considered it. Okay.
Lordship, my instruction was that the same due to some technical error or a human error, Lordship, it could not be so. So they have asked me that if they can, because under Rule 108, the commissioner has the only power to allow acceptance manually. Where in the situations where.
But they have also already done electronically.
Since I think the district authority has not informed the appellate authority that it has been resolved, Lordship.
What is your name, madam?
Yes, sir.
Miss S. Heard Miss S. Sarkar, learned counsel for the petitioner. Also heard Sri B. Chaudhary, learned standing counsel, state GST. Full stop. On the last occasion, this court was informed by the learned counsel that an attempt was made for redressal of the issue. Full stop. Para. This court has been informed today that the petitioner has submitted the appeal electronically.
Lordship can take into account the provisional acknowledgement that has been.
Which has been acknowledged provisionally. Full stop. Para. Though Sri Chaudhary, the learned standing counsel, does not have ready instructions on the aforesaid aspect, he submits that if the same has been acknowledged, if receipt of the same has been acknowledged, the same would be considered in accordance with law. Para, in view of the aforesaid undertaking, the instant writ petition is disposed of by directing consideration of the appeal of the petitioner on merits and in accordance with law.
Lordship, the IA will be disposed of because Lordship already granted some, they have prayed for extension.
Okay. Appeal, the IA. Dispose of the application, IA. Okay, next.
My lords,
Yes,
I
19.
appear in item 19, my lord.
Yes.
I hope I'm audible and visible, my lord.
Yes.
My lord, in this regard, I would like to draw your attention of the lordship that already in this case, argument has been done earlier, and we have submitted written argument. Written sufficient.
Yes, my lord.
Before whom?
Before another bench, my lord, it was done. It was argued on April 25, my lord. The judgments were reserved.
No, before which bench?
Before court number 16, it was. I'm newly engaged in this, my lord. It was argued by my predecessor.
Oh, my lord, about the justice. It has done it. It was fixed for that.
Honorable Justice Jamir is not there in this court now. That will not make any difference. We have to rehear it.
Very well, my lord.
That will not make any sense. We have to rehear it. It is for hearing today.
My lord, I am ready to argue. I am appearing for APEDA, the writ petitioner, my lord.
You are challenging an award.
Yes, my lord. I am
Who is the
challenging.
local council? Is anybody there? There's nobody. Is there any local council there to assist this court?
For us,
Yes.
my lord, my local counsel was there. I don't know where had she gone.
We need somebody to be there. We don't mind hearing you online, but these are for final disposal. This is
Yes,
not
my
for
lord.
some
Ye-
interlocutory
No, my
consideration.
lord. No, my lord. In fact, the award is stayed by your lordship. And this relates to contractual matter, my lord, wherein the contract has ended
Volume
for respondent.
Volume.
Though I'm entering into the merit, my lord, but
You have to. You're not very much audible. You need to increase your volume also.
my lord, am I audible now?
Yes.
My lord, this matter pertains to the award wherein the respondent, he was our employee, a contractual employee, and he was not terminated. The contract ended. He wanted us to extend the contract, which was refused by us. He went to industrial tribunal and he got the award wherein he was asked to be reinstated, which is the subject matter before your lordship. That award is challenged by us. Primarily, my lord, only two dates I would like to give, my lord. One is that he was appointed in September 98. Then his off and on he was continued, and his last appointment was on 8th July 2011. My lord, may kindly have page 104 for a moment. 104, my lords.
Okay.
Now 104, my lord, may have the appointment letter. It has a bearing, my lord, because it categorically says 104. The contract my lord has it. Annexure G.
Yes.
104, my lord. This is the appointment letter wherein the first serial number is contract is for a specific period of 6 months. The post was a peon. 3 is important, my lord. The engagement of the services of this contract shall not create any
Mr.
right
Bedi,
or
please address
relation
it.
of
Yes.
shall not create any right or relation of employee and employer. 4, the contract shall not bestow any rights to Mr. Burman for claiming regular employment in this authority. Then my lord may have 8. 8 is important.
Yes.
The contract shall stand rescinded automatically at the last date of the contract. Serial number 8, my lord. And then 10. During or after the contract, it will not confer any right to Mr. Burman or for any claim or rights for any benefits which are normally available to regular employees. Now, so these were the terms and conditions on which he was employed. After employment, my lords,
Yes.
his contract ended and it was not renewed. In fact, we did not have anyone. We have only 2, as per I'm stating on the record, my lord. We at that point in time we had only 2 employees there and one one contractual employee in form of peon. Now, after this, he went to he filed two cases, my lord. One for gratuity, the other for reinstatement. Gratuity issue is settled, wherein he succeeded. We were directed to give around 68,000 to him. The same, we came before your lordship. Our writ was dismissed, and we have given that gratuity part. This present matter only relates to the reinstatement part. Now, my lord may kindly have the impugned order.
Yes, page.
It starts from page 39. The relevant portion, my lord, may kindly have 39G. 39G.
Yes.
Para 9.
Yes.
On perusal of the materials, my lord has got. On perusal
Yes.
of the materials on record, it appeared that engagement of the workman on the basis of contract agreement for more than 13 years with certain breaks is not in dispute. Admittedly, his engagement was discontinued from 1st January 2012. In other words, the primary facts are not in dispute. It was clear from the materials on record that from 98 to 2011, the workman was working as peon in the office of APEDA, Guwahati with certain breaks. His wages were directly paid by the management. His original appointment was given by the head office of APEDA in New Delhi. Now, this two line, my lord, may kindly mark. Accordingly, there appeared a clear employee and employer relationship. Here lies the infirmity, my lord. The tenure from 98 to 2011, wherein he was contractually appointed several times through various orders, will not make him a regular employee. Wherein, where I had already shown, my lord, that apart from stating that you are a regular employee, you will not be conferred any regular status. Now, my lord, may kindly have page 39H. My lord.
Yes.
Last para I am reading, my lord. In view of the facts and circumstances, as discussed in the preceding paragraphs, it appeared to me that though technically engagement of the concerned worker was in terms of exhibit so and so, the sheer length of his continuity in the job is bound to lead to a natural inference that he was an employee of the APEDA. Now, this finding that he was an employee of the APEDA is directly in face of our contract with him. Guwahati, though
Yes.
Guwahati, though to lead to a natural inference that he was an employee of APEDA. Next part is interesting, my lord. Though not a regular one. Now, the tribunal itself says that he was not a regular employee and then goes on to give a direction for reinstating him and extend him the benefits of 25F. So the concluding part, my lord, admittedly he was not a regular employee, but the materials on record show that the nature of work done by him was of perennial nature. The workman worked for 13 years and therefore he must be reinstated. Now, my lord, may kindly have Industrial Dispute Act for a moment. This finding is directly in contrast to the exclusion which is given in the act itself. My lord, may kindly have 200, which defines retrenchment, my lord. 200, my lord. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever otherwise than as a punishment inflicted by way of a disciplinary action. This we are not contending, but does not include, my lord may mark that and kindly see double B, but does not include termination of the service of the workman as a result of the non-renewal of the contract of the employment between the employer and the workman concerned on its expiry or of such contract being terminated under a stipulation in that behalf. So our case is squarely covered by this double B, my lord, wherein his employment ended as the contract itself ended, and therefore he could not have been given any benefit under 25F, which talks about reinstatement in cases of retrenchment, because his removal is not retrenchment, is our case. Now, my lord may kindly have our written submissions, which we have filed already before the lordship. 3 to 4 important points only. I'll just take 2-3 more minutes, my lord. One is that it's an admitted position that respondent 3 was a contractual employee. His first contract is at page 102 and his last contract is at page 104. This is a case wherein he was aggrieved by a non-renewal, and kindly have his his claim petition at page 133, which categorically reinforces this, that he was aggrieved by the non-renewal of his contract. Paragraph 8 may be seen, my lord. 133.
Page
133, para 8. First para, my lord, at 133, that the claimant in the aforesaid manner worked as a temporary employee of the APEDA, and thereafter the services of the claimant was terminated without any notice. So he expects a notice from us, wherein our case is that since the contract has ended, we need not give you any notice. Had it been during the currency of the contract, yes, you for terminating, you are to be given a notice, and then everything has to be followed. Now, my lord, apart from this, it was a purely contractual thing, and he was not, and we have cited, my lord, Supreme Court's judgment in Management Development UP Pushpa Srivastav. I am not troubling a lordship to take through that judgment. We have already filed it. And my lord may kindly have para number in the compilation, my lord.
Just a minute.
Sorry.
What are you referring?
We are referring to 1992 4 SCC 33, the compilation, my lord, which we have already submitted. Earlier it was submitted, my lord. It is on the principle, my lord, that if a contractual employee is removed, not removed, in fact, his contract is not renewed, this non-renewal will not lead to retrenchment as envisaged under the ID Act. This is the principle, my lord, which we are.
Which citation you are trying to refer?
Srimati Pushpa Srivastav judgment, my lord, 1992 4 SCC, page number 33. This is the first judgment.
Pushpa
Srivastav. My lord, if need be, I can supply the I can resupply the compilation part, my lord.
No, you have given one Surendra Nagar District Panchayat.
Yes, that is on
Kishore Samal, Dipali Gundu, Rasmi Belen. And one is given by Mr. Day. Mr. Day has,
My lord, then, my lord, may I submit, may
Oh,
I
just-
resupply the entire thing, my lord?
just,
Only the compilation part.
just let me check if it's there. Pushpa.
It is Director Institute of Management Development UP versus Srimati Pushpa Srivastava.
Not there.
My lord, may I share with you? I can share the soft copy, my lord. Or I'll get it filed, my lord. Give me 2 days time, I'll get it filed, my lord. I'll just read the relevant portion.
If you have already given it, it should be there.
My lord,
Others we have. We
My
have
lord, I'm-
4
I'm-
case laws which you had presented.
yes, my lord.
Surendra Nagar, Kishore Chandra Samal, Deepali Gundu, and Rasmi
Only
Balan.
this one is missing. I am going by the written submission which is
Now,
filed by
what proposition? What proposition?
the proposition is, my lord, I'll just say. The
Please give the
proposition is,
citation.
it is 1992 4 SCC 33. The proposition is that this case, like in Pushpa Srivastava, falls within the exception which I just showed to your lordship in the act, and the proposition is that the non-renewal of a contractual employee, the non-renewal of the contract of a contractual employee would not amount to retrenchment, and therefore no benefit can be given under 25F of the ID Act, directing us to reinstate him.
Yes.
Right. Now, the next is, my lord, that we, in such cases, we are not required to follow a procedure as envisaged in 25F. Again, the same logic goes, my lord, since it's not retrenchment, 25F procedure need not be followed. And same is being said by in Surendranath. Paragraph 7 may be seen, my lord, of the compilation. Paragraph 7, page 7 of the compilation is we are relying upon. Just one second. When done.
Yes.
No, there is some. My lord, may kindly just give me one moment. Kindly bear. So, this is the proposition at paragraph 7, page 7 of the compilation. Now, my lord, the respondent number 3, the third proposition is, my lord, he cannot claim continuation of service as a matter of right after accepting the terms and condition under which he was appointed. I have already showed to your lordship at page 104 that no right flows to him, and such conditions are not hit by any public policy or can be said to be unreasonable, my lord. This is the third proposition, and for that we have relied on Rasmila Bahan R. Thakkar, page 52 to 61, para 5.2 of the judgment, of the page 52 of the compilation, my lord. Para 5.20 onwards, page 52 to 61.
Gujarat High Court.
Yes, my lord. My lord, the proposition is that if the contract itself rescinded automatically with the influx of time, then you cannot claim as a matter of right, having accepted those terms and conditions, having fulfilled both the parties. My relationship with him is purely contractual in nature. During the contract, he doesn't have any call. It's only after the contract. As a matter of right, he cannot claim it. that he must be continued, particularly when there is no allegation of any Article 14 violation or he being distinguished or someone else has been joined or favored. There is no such allegation. Now, my lord may kindly note that his appointment was not against a sanctioned post and no post exists. This bears importance, my lord. Kindly have page 85 of the writ petition and page 100. The number of employees which I was earlier talking about, we have only 2 sanctioned posts, one of assistant general manager and the another is page 85 of the writ petition. 85.
Yes, please.
Just one. Page 85, my lord, may kindly have. Yes. This is our internal letter, and wherein we have said at para 2, my lord, APEDA may fill up the vacant post within the existing sanctioned strength of that particular cadre only. Additional post, this is Government of India writing to us, my lord. Additional posts of particular cadre as recommended in the restructuring proposal can be filled only upon approval of Department of Expenditure for the same. Similarly, the promotional posts may be filled up within the sanctioned strength of that particular cadre only, and promotional positions on account of additional posts to be created in particular cadre can be filled up only after approval of Department of Expenditure. It may be noted that approval of Department of Expenditure would be required for creation of new posts. Our case is that he was appointed on a non-sanctioned post, and that's why he was a contractual employee. And for that, my lord, we are relying on the judgment of Dipalu Survase. Judgment compilation is at page 16, my lord. 16 to page 16 it starts. We are relying upon paragraph 21 and 22, which is at page 36 of the compilation. Paragraph 21 and 22 of this judgment, my lord. Dipali's judgment. Page 36, my lord. And last, my lord, should I read those paragraphs or?
Just a minute, please.
Yes.
Page 36.
Yes, my lord.
Yes.
Just one second.
Yes.
Para 21, my lord. I'll just read. Now it reads, my lord, page para 21. The word reinstatement has not been defined in the Act and the rules as per the shorter Oxford Dictionary, and then it goes on to discuss the meaning of the word reinstatement through various dictionaries. I am not troubling your lordship with all that. Para 22, my lord. The very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been but for the illegal action taken by the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. With the passing of an order which has the effect of severing the employee-employer relationship, the latter's source of income gets dried up. Not only the employee concerned, but his entire family suffers. They are deprived of these.
We
So
read this.
all these principles, my lord. And last, my lord, the length of service which appear to have weighed with the tribunal, my lord, is not relevant in temporary nature of engagement, my lord. Had it been a permanent post, then yes, but length of service is not a relevant consideration when you are evaluating the removal or termination of a contractual employee. Particularly in this case, wherein we have not removed anyone, he is not given a reappointment. So it's a case of reappointment, a contractual, it's well settled, my lord, that a contractual employee cannot, as a matter of right, claim reappointment. This is the long and short of it, my lord. This is all which we wanted to argue, my lord.
Yes.
I'm so grateful for a
Yes,
peaceful.
Mr. Day. Yes, Mr. Day.
hearing.
One point I would like to go through your notice. I have been granted interim relief under section 17B. By order dated 14/12.
What is your age now?
Pardon?
What is your age?
What is 56?
Around 56.
Around 56.
You are R3. You are SP number 3.
Yes.
Workman. Now, 17B, you need not argue at this stage. We are hearing the final, we are going for a final hearing, and
Am I
we've
not
heard
on?
the other side.
One point.
You can advance your arguments on the merits of the case.
Just as per order, I am entitled to interim relief from the date of judgment, the date of award passed by the Lauded Tribunal.
So, Dave, do not waste your energy there. Come argue on the merits. 17B is at the time of motion. Now we're at the final disposal.
Yes, I know.
If we are not agreeing with the petitioner, we'll get everything. If you're agreeing with the petitioner, there is no question of 17B. Please make your arguments.
But they have paid from the date of filing of the writ petition before this court. This, I would like to point this out.
Yes, okay, we have taken into
Thereafter,
consideration.
Since the
Yes.
date of filing of the writ petition, they are paid.
Yes.
So this, we have submitted an application in this regard, and which was lying pending, not the closed door. So this may kindly be in procedure. My lord, regarding appointment of the respondent number 3, kindly have a look on APDA regulation. Totally enclosed with my written submission, for us it is available on.
Yes, is there? Page?
Page 3, my lord.
Yes. Yes.
Page 3. According to the said regulation, chapter 5,
Yes.
the methods of recruitment, condition of service, etc. of employees of OPDA in clause 28, subclause 1, appointment to the service of the authority may be made by any one of the following methods. Number 1, direct recruitment. Number 2, promotion. Number C, deputation from the central government or state government or from any other government autonomous organization.
Yes.
Contract appointment, my lord, my appointment comes to the close category of contract appointment. I was appointed under category D. That is contract appointment directly by the head office of the writ petitioner, not through any contractor or intermediate employer. My actual contractual employment is one of the 4 type of method of the appointment in APDA. My service was directly controlled and supervised by Guwahati Regional Office for the petitioner, and my wages were also paid by the writ petitioner directly from head office at Delhi. My work was also supervised by the local authority, and my wages was also not given by any contractor. So I am not a contractual employee, my lord, in his 2 cents. This type of contract appointment continued.
Mr. Dey, you are trying to make a distinction between a contract labor. Contract labor we can understand under a particular statute. But if you say that you are not a contractual appointment, then what kind of appointment you are holding?
I am appointed directly by the.
No, it is on the basis of what? Why it is limited by a particular period? How do you distinguish the services of your client with a regular employee? See, your every term is, every appointment on contractual basis is for a particular period, whereafter there is another contractual employee appointment.
Yes.
Now, if such appointment order was not issued, the relationship gets severed. You do not have a right to continue till a particular period or a particular age, unlike a regular employee. So how do you justify your contention that you are not a contractual employee?
My lord, the nature of work, I have been working perennial in nature.
So that is a different aspect. That is on the length of service, the nature of work. That has got nothing to do with the nature of entry into the service. You can concentrate your argument on the other aspect, that the work which I am discharging is of perennial nature.
Yes.
It could not have been discontinued. So you cannot treat me as a contractual employee. That it is up to you to make a submission. You can make your submission.
My lord, they terminated me without any notice, without any purpose.
But is it required after the period is over? Oh, I did not get your name, Mr. What is your name for the petitioner?
Yes, my lord.
Your name.
Avanish Kumar.
Mr. Kumar has submitted that the discontinuation was not in between. The discontinuation was after completion of the period. So he said that there may not be a requirement of a notice. More so when the contractual terms of your engagement clearly says that there is no requirement of a notice, and once the period is over, the contract is over. It stands rescinded.
Lord, actually, he worked after his termination. He was allowed, and he has not been given any notice, not any written order or any sort of instrument. He worked. Subsequently, they put some allegations against him that he has stolen some official record from their office. But actually, my lord, after his termination, novel termination, he submitted representation, and they also forwarded this said representation to their headquarters. My lord, in my written objection, written submission, page 94-95.
Yes.
95 is his representation, and 94 is the forwarding letter. Mr. Vinod Chandra Burman, whose service was hired by FADA on contract basis at Regional Office Guwahati, has submitted an application requesting FADA to extend his service with promise to discharge his duty sincerely in future. Mr. Burman's contract service as peon was over on 31 December, 31st December 2011, and he has served. His service was not extended due to negligence of duty and resort to argument with with AGM FPDA Guwahati. He was also he was asked to submit in writing that he would be sincere to the duty and in future, and when he come to RO office, that is regional office, in January 12 after the break, but he finally decided to submit the letter only today, that is on 26 March 2012, after a gap of almost 3 months. In this regard, we request you kindly attend to our mail sent on 26 March 12. If Mr. Vinod Burman decides to discharge his duty with sincerity and devotion from now onward, as he promised through his letter from his letter, then FPDA may overwriting in this letter value. May kindly consider to hire his service again. We will also like to express again that we have limited manpower as regional office Guwahati. Therefore, the regional in charge always face lot of difficulties while discharging his duty in difficult region, like any coordination and cooperation from everyone is very much required. Otherwise, the office will not run smoothly. Hope Mr. Burman has realized his mistake now and will never repeat the same mistake once his service is hired on contract basis. The letter from Vinod Burman is attached herewith for favor of your kind
Yes, we have
information
read.
and suggestion. Page 95 is the letter.
Letter we have seen.
My lord. Moreover, being a contract employee, he served a long period of time. He spent his valuable days of his life, and in this connection, my lord, he served 240 days. It has been shown, but whole year, without any day, without any questions, and they actually for to protect their skin, or some other benefit, they have tempered the varieties are there. Procedure collected by the from CGAP. Also, paper. All each and all paper what I think. Then
intention is not elaborated. One thing, my lord, is here was also deducted for these wages. Computed in the account. I would like to put your resolution. Honorable people. Please, I feel 32 I invite. Somebody, Kalikat Bhaksas, Alat Actually, Don and August, 1978, 257. There are 2, 5, and 6 attacks from whole, well, same opinion.
Yes.
Not in dispute. That when Indian workmen were denied employment, which led to the difference. It not in dispute that the work done by them, by these workmen was an integral part of the justification. That raw materials were supplied by the management, that the actually premises belong to the management, that the equipment belong to the management, and that was taken by the management for its own trade. The workmen were broadly under the control of the and the articles are directed to be rectified by the management. As part of this organization of circumstances, of a question, but yes, is time and again when we need to pass speaking word. You should have thought that there is the impressive array of factors are not present. Would have persuaded an industrial form to crucial to be contributed with the economic players the people. Clarify. The two tests made with gravity be indicated once again, where a worker or group of worker labors who produce goods, services, and these goods or services are called whether that other is in fact the employer. He has economic control over the workers' substance, skill, and continued employment.
Yes, we have read this, we have read, Mr. Day.
Last one, before must be avoid mischief and mischief purpose of law and it by law and legal appearance. Thus, seems if the likelihood of the workman substantially depends on labor rendered to produce goods and services for the benefit and satisfaction of the place, the absence of distinct direct relationship of this intermediaries or the make believe stepping of detachment from the management cannot left the real life form, story there, very, but the inference device, identity cannot be shaken. This regard, Honorable Tribunal has rightly agreed with the opinion. Yes. And in his award dated 1/10/2019, in para 9, 34.
Mr. Day, you have to meet the contention advanced by your colleague on the other side. He has referred to section 200 regarding retrenchment and the exception under BB, that it does not include termination as a result of non-renewal. Now, here is a case that his services could not be continued because of non-renewal of a contract. So it is not a retrenchment. If it is not a retrenchment, then will the labor court or tribunal have a power?
My lord, this type of arbitrary act committed by the management is unfair labor practice because they already require the service of respondent number 3. They have already forwarded the presentation submitted by respondent number 3. In their evidence also, as management witness number 1, Sunita Rai, in her evidence, categorically mentioned, my lord, page 91, para 7. Para 7. That the annexure number 10 as submitted by the workman along with his plain petition is a confidential official communication even protected under section 126 of the Evidence Act 1872 between the management which was stolen by the workman. Earlier, as also the workman used to steal such confidential document from the office for which the local management has lost all his faith and trust upon the workman, and as such, it was decided not to renew the contractual agreement of the workman. So much so, PDA regional office has already hired a peon on contractual agreement basis through service provider, and thereafter there is no requirement of additional manpower at the level of peon. My lord, they are engaging men to some service provider, whereas I work such a long period, putting some false and frivolous allegation against me. They are terminated me. Okay. My lord,
a PDA came into existence by the Government of India under an act of Parliament. As such, discontinuation of closure or of any of its office need amendment in the act itself. The PDA is neither a project nor a scheme of short duration which will close automatically after. a
Where are you
specific
reading?
period.
What are you reading? What are
Page
you reading?
Page 5 of my
Five.
subject.
Yeah, this will, written submission will take into consideration.
So they have sought protection under section 200 B of ID Act 1947 of this case. In this regard, Honorable Supreme Court in Haryana State Electronic Development Corporation Limited versus Mamuni 2006-9 SCC 434 in para 9 and 11. My lord, page 43 to 48 of my written submission. Para 9 and 11. Para 9, the respondent was appointed from time to time. Her service used to be terminated on expiry of 89 days on regular basis. However, it is noticed that she used to be appointed after a gap of 1 or 2 days upon completion of each term. Such an action on the part of the appellant cannot be said to be bona fide. The High Court rejected the contention raised on behalf of the said appellant herein, stating it is not possible for us to accept the aforesaid plea raised at the hands of the management on account of the fact that the factual position which has not been disputed reveals that the respondent workman was repeatedly engaged on 89 days basis. It is therefore clear that the intention of the management was not to engage the respondent workman for a specific period as alleged, but was to defeat the right available to the under section management available to her under section 25F of the Act. The aforesaid practice of the hands of the petitioner management to employ the workmen repeatedly after notional break clearly falls within the ambit and scope of the unfair labor practice. Para 11. In this case, service of the respondent has been terminated on regular basis, and she has been reappointed after a gap of 1 or 2 days. Such a course of action was adopted by the appellant with a view to defeat the object of the Act, section 200 B of the Industrial Dispute Act 1947. Therefore, is not affected the instant case. In my case, my lord, similar thing they did. They have tempered their attendance register, and later on they maintained separated attendance register for me. I was not allowed to put my attendance on the register, consolidated register made by the authority concerned.
Oh, so that's.
Then, my lord, I am not.
Yes, please complete it. We have to rise early a bit.
Okay.
Okay.
My lord, I am not paying for regularization, only for reinstatement. In this regard, the decision of Honorable Supreme Court in Anup Sharma versus Executive Engineer Public Health Division Number 1, Panipat, Haryana, 2010, 5 SCC 497. There are, sorry, page 49 to 60, my lord. Para 17. This court has repeatedly.
Page,
Page 6, my lord.
67
Hmm.
of the compilation.
49, no,
61.
Yes, my lord.
ONGC case.
No, my lord. Anup Sharma case.
Page
Anup Sharma case, page 49 to 60.
49. Okay, Anup Sharma.
Para 17. This court has repeatedly held that section 25F, A and B of the Act are mandatory and non-compliance therewith renders the replacement of an employee nullity. In para 22, my lord, 22, page 58. If the workman is retrenched by an oral order or communication, or he is simply asked not to come for duty, the employer will be required to lead tangible and substantive evidence to prove compliance with clause A and B of section 25F of the Act. In General Manager ONGC Silchar versus ONGC Contractual Worker Union 2008, 12 SCC 275. My lord, page 61 to 70 of my written submission.
No, Mr. Day, you tell us one thing. In absence of an extension of the contract or a new contract, could you have continued in service?
Well, I have done perennial nature work. And I have.
No, you have argued that the nature of the work is perennial in nature, perennial. Now, the last appointment was for a period 8/7/2011 to 31/12/2011.
Yes.
In absence of another order by which your employment is confirmed, under what right or under what strength of what order will you continue?
My plan is, my lord, just to reinstate me because I
No,
was.
the reinstatement would come when you are retrenched or removed without any authority of law.
Yes, my lord.
For that, you have to make out a case that after the expiry of 31/12/2011, you still had a right to continue in the job.
But
Now, the aspect of misconduct has not come. It is not a question of misconduct or an inquiry. It is a question purely on non-extension of a contract. Now, can you claim as a matter of right that the contract of your employment has to be extended?
My lord, I was allowed to work after expiry of the contractual period, for a long period. Although it is not on record.
That is the difficulty.
And subsequently, they raised some allegations of thefts and
No,
misconduct.
those will not side with the management. Those allegations are not the subject matter of dispute, neither in the tribunal nor before us. Tribunal has based the award with certain observations, including those which have been pointed out by Mr. Kumar. Now, having made certain observations, will an order of reinstatement be justified?
My lord, this court is empowered with vast authority and discretionary power. And it is.
No, Mr. Dev, the powers which you are exercising in examining an award is a different power which we exercise when a citizen comes before us for enforcement of his legal rights. We are on certiorari jurisdiction. We are only on the aspect whether the decision taken by the authority which is the subject matter of challenge is based on the relevant factors, or whether it is based on irrelevant factors, extraneous factors.
Honorable Supreme Court repeatedly issued directions for malicious action against the poor laborer. And this legislation has been made for the benefit of this laborer. So in this respect, he is helpless. Now he is not in a position to work, not in a position to just some working as a watchman of a flat.
Yes, Mr. Kumar. You unmute. Not hearing you. Unmute yourself. Not audible.
My lord, now am I audible?
Yes, yes.
Yes, I'm so sorry, my lord. My lord, only two things. Once having got the gratuity, he cannot seek reinstatement. That is one. Number two, my lord, insofar as the nature of work he was doing, he has made an averment at page 136, para 15. I'm reading from his claim petition, wherein he has said that he was doing perennial nature of job and claimant was a contributor of CPF and GPF. Now all those, so apart from this bald statement, there is nothing on record, and this statement was denied by us in our written submission, in our reply at page 179, para 19. Now, my lord may kindly see his deposition. I'm only on the limited aspect of the nature of work which he was doing. Even, firstly, there is no pleading. He cannot, we are bound by the pleadings which is before the tribunal. I have shown the pleading only by telling that he was rendering some perennial nature of job.
Let us cut it short. Mr.
Yes, my lord.
Kumar, you
Yes,
are
my
not in favor of a reinstatement.
Yes, my lord.
You're not,
We are
that is why we had asked about the age of the workman. He's 56
He
years.
is 55.
But
55.
are you we are just asking you.
Yes, ma'am.
This is a loud thinking. Whether you are willing to give him some compensation.
Lord, for that I need to seek instruction. Whether on a limited aspect of compensation, my lord, because 13 years have gone by and he's already gainfully employed.
That gainful employment has got nothing to do with 17B. Since
Yes.
The challenge is pending before us, and
Yes.
he's strengthened by the award of the
I quite get that,
tribunal,
my
which is the subject
my
matter
lord,
of
my
challenge.
lord, I need to
Even
seek
if we
instruction.
agree with you,
Yes, my lord.
by exercise of powers under 226,
Yes, my lord.
whether any lump sum amount would be, see, he's a workman, poor workman. We understand the plight, but we're just trying to strike an balance.
Balance. I quite get that, my lord. I need to seek instruction on this.
But
this
when can we come back?
my
Tuesday?
lord, Tuesday would be
Wednesday.
My lord. Can it be 29th, my lord? Actually, from Till 20th, I am traveling. So I'll
29th.
29th,
29th.
29th,
We
29th
have
January. my lord.
completed the hearing, Mr. Day. But we'd like to have a little bit of, that will not have the final say on our judgment, but we're just trying to have his views.
Very
Okay.
well. My lord, I'll seek instruction on and join on 29th.
Mr. Avnish Kumar, what is the Avnish? Avnish
Yes, my
Kumar,
lord.
Learned Counsel for the petitioner appearing online. Also heard 3 LCD, Learned Counsel for the respondent number 3. Madam, you are there. The matter has been substantially heard. Sri Kumar, the Learned Counsel for petitioner, prays for little accommodation to seek instructions, further instructions, list for hearing on 29th.
29th. Obliged, my lord.
Much of it.
What matter, Mr. Sharma? Now, what is the matter about it?
My lord, actually what happens in this case, my lord, lease agreement was entered into between 2011 to 2016. my lord.
Regarding?
Oh, it was settlement.
Okay, then?
Thereafter, my lord, what happens, that settlement was made under 1994 rules. Some minor mineral concession
yes.
rules 1994. And my lord, I have operated the mall, stone quarry, for entire period on 16. And 2018, my lord, suddenly one notice came to us that you have to deposit 6 lakh something for MMDRR under Assam Minor Mineral Concession Rules 2013. That is the issue before this one.
Yes, Mr.
We have contended in our affidavit that when rules of 2013.
Okay, we'll fix it.
Yes, ma'am. Some other they are convenient to the honorable court, ma'am.
Paucity of time will not allow the matter to be taken up today. List for hearing on 3rd of February.
Madam,